paid for September. We have some reviews to do for people who have orders to accomplish, and this is a check on that. So when your name's called, come up to the table to the right for review. And then we'll start the new cases after that's concluded.
Matthew Gonzalez, Joseph Graham, Kenneth Holzapfel, Ashley J. Huff, Kimberly Jones, Harry M. Rude.
Matthew Gonzalez is here, 22377, 22362, 22343, 22309, 2277. And I think you just have to pay fines, is all that's on these cases. You have a payment today, Mr.
Yes, Your Honor.
Gonzalez? How much are you going to pay?
$50.
Okay. See the clerk about that.
Yes.
October the 10th will be your next hearing.
Yes, Your Honor. Thank you.
That's a Tuesday, because the 9th is a holiday.
All right.
Wednesday. So October the 10th at 9 o'clock, see the clerk.
Yes, Your Honor. Thank you.
Joseph A. Graham. $23.75 is the case number. Mr. Graham has been called, didn't appear, has not finished his case, so there will be a warrant issued for failure to appear. Kenneth Holzapfel. 19-194, 18-956 and 57, 18-3473, 18-12, 64. Looks like your community service is completed, so you're working on your funds now.
Yes, sir.
Actually, 18-12-64 is completed. That's been paid and community service done. Do you have a payment on your outstanding fines?
Yes, sir. I have $80 today.
Okay. All right, see the clerk, and October the 10th will be your next hearing.
Could I get that for a Friday? I have Fridays off at work.
Okay, October 6th.
October 6th. Thank you.
Ashley Huff is here. 2758, 2724, 25, and 718. Are you able to pay anything on your fines?
Yes, sir.
How much are you going to pay?
50.
All right. See the clerk to pay that. I'll set your next hearing for October 27th.
Thank you.
Kim Jones has been called for, did call the clerk today and said that she was ill, could not be here, so I'll continue it for 1 week to September the 15th. If she doesn't hear it then, I won't wish you. Harry Rude. 220805 and 21392. It's called not appeared. He still has things left to do, so there'll be a warrant issued.
William T. Roy, Bree Sifford, Donald R. Waddle, Mark Wells, Joseph Edens.
Mark Wells is here.
Yes.
17-1273. 2014. 05-2169. You're working on paying your fines. Do you have a payment today, Mr. Wells?
Yes.
How much are you paying?
22.
20?
$22.
22, okay. October the 10th would be your next hearing. We have a report from Mr. Edens. Are you Miss Woodrum? Are you Heather?
Yes.
Okay. You're the author of this report then?
No.
This is a different Heather?
Yes.
What's your last name?
Fields.
Fields, Heather
Yes.
Fields. Thank you for being here. If you could give your contact information, because I understand Mr. Webb's no longer an employee, he was the
Correct.
liaison. I have, over the last couple of weeks, I've sent him a few texts about
I do
folks from the
apologize.
court that we were expecting reports and didn't get. We never responded to those texts, so I can forward those to you so you can get us reports.
Yes.
I have her contact information, Your Honor. She came and gave it to me last week.
Okay, very good, if you give it to me after court. And we will be having, our treatment
First of the,
provider meeting will be Monday, this coming Monday,
okay, I'll be here.
at 8:30. So he's an outpatient now?
No, he is in Glenville and,
Okay, that's what I thought.
yeah.
So that's why, and I'll excuse his absence then because he's in inpatient treatment. Okay, it looks like he's doing what he needs to do. I'll set the next hearing for October the 20th.
Okay, thank you.
You're welcome. William Roy was called, didn't appear. 19-1748, 19-473, 15-554. Okay, it looks like he's done everything that his community, he has some community service on one case he didn't complete.
Correct.
Okay. So there will be a warrant issued for failure to appear because he still has obligations to complete. Bree Sifford is 19-1239. She has community service and fines left to pay. The bench warrant issued, Donald Waddle, 22-1371. He hasn't done anything on his case. He hasn't appeared today, so he'll get a warrant. Okay, that finishes the review hearings. We'll start the arraignments next, which are for new cases or old cases where there was a hearing missed in the past. And if you are one of those people, you missed a hearing prior, you need to check in with the clerk so they'll know to call your case. You're not on the docket if you missed a hearing previously. If you want to get that resolved, you need to go check in with the clerk so they'll know to bring you on the docket today. When your name's called, come up to the table to your right, stand there. I'll go over the charges with you. You have a right to remain silent. You don't have to make any statements at all. But what you do say is on the record. Everything's being recorded here. So it can be used against you. If you get up and admit that you did what's alleged against you, the prosecutor can use that admission against you later in the case if you decide to deny it later. You have a right to have an attorney. You have a right to have one appointed if you're facing jail and you can't afford one and meet the guidelines. So I have to ask you about your income if you want to appoint a lawyer. You have a right to bail and to make the state prove any charge against you beyond a reasonable doubt. Those rights all defendants have. You waive those rights by a guilty plea or a no contest plea. So don't enter those pleas if you don't understand what's happening. If you want to talk to a lawyer or if you want a trial or if you don't know what to do, you should enter a not guilty plea. That preserves your rights. You can change it later if you want to, but you should not enter a guilty or no contest plea just to get things over with. That's not a good reason to enter one of those pleas. Call the first case.
State of Ohio versus Ellen Phillips, case number CRB 23-546 and TRC 23-1249, A and B.
Are you Eleanor Phillips?
Yes.
Ms. Phillips, the state's alleging that on September the 1st at 10:48 p.m. in Perry Township, you were driving a vehicle while you were under the influence of alcohol, that you took a breath test and tested 13 on a breath test. The state's also alleging this is your first offense. So on a first offense, the maximum penalty is 6 months in jail, a $1,075 fine, and a 3-year license suspension. That's the most that the court can impose if you're found guilty. There is a minimum, which a lot of the charges don't have minimums, but this one does have a minimum that the legislature set. So if you're convicted or plead guilty, I have to sentence you to at least 3 days in a treatment program, a $375 fine, and a 6-month license suspension. That's the minimum. Your breath test score, it's almost 14, but we'll just round it off and say 13, is above what's called the per se level under Ohio law. And what that means, if there's a test score of 8 or higher on a breath test, then there can be a presumption that you're impaired attached to that test score. To get the presumption that you are impaired, the state has to show compliance with the rules like calibrating the machine and that sort of thing. So there's some things they have to show in order to get the presumption that your test score is above the per se level on the face of it. You're also charged with having illegal window tint, too dark window tint. That is a minor misdemeanor. Maximum penalty is $150 fine. Then you've got case number 23-546 is a charge of having possession of marijuana less than 100 grams. So that's a minor misdemeanor. Maximum penalty is $150 fine. So you have those 3 charges. Do you understand the charges?
Yes, I do.
You understand the rights I explained?
Yes, sir.
How do you wish to plead?
Not guilty.
Do you want a lawyer appointed to represent you?
No, I'll get my own.
How much time, have you hired somebody yet?
I have not.
How much time do you want to try to do that?
Couple weeks, if I could do that.
Okay, I'll give you at least that. Let me see what the court's counting. Let's make it, are you working?
I am. I'm a full-time I work full-time and I'm also a full-time mother. So I have to get my daughter back and forth to school, and
Well,
to and from
courts are
daycare.
generally, except for holidays, on Mondays or Fridays. Do you have a preference between those 2 days?
Preferably Friday.
Okay, I'm gonna make it September 29th.
Okay.
So that's 3 weeks from today. Oh, okay, I'm gonna change it then. We have a jury trial scheduled to start that afternoon, so I'm gonna have to keep that light. So let's go into October. October 6th is Friday, first Friday of October. October 6th, I'm scheduling as your next hearing. Now, if you hire an attorney, they tell you they've made arrangements for a different date, come on the date that your attorney tells you. They may continue it if they have something else already scheduled that day.
Okay.
I'm entering a not guilty plea for you, and I'm going to let you sign a signature bond of $1,000. What that means is you're signing a piece of paper that's like your promise to come to court. As long as you show up, you don't have to post any money. If you don't show up, then you get a warrant for not appearing, and you're required to pay the $1,000 as a penalty. Just come to court, you won't have to post any money. Do you have any questions, ma'am?
About my license, it was suspended last Friday. I kind of need it to get my daughter to and from daycare and school. Is there a way that I could get?
Well, you need to talk to your attorney. There's required to be what's called a 15-day hard suspension, and then I can give you some driving privileges, but it would be limited.
Right.
So talk to your attorney, and they can file a motion. You have to file a motion with the court for special driving privileges, but I can't give it to you for the first 15 days.
Okay. And what time is court on the 6th?
10 a.m.
10 a.m. All right.
State of Ohio versus Randy Thompson, case number TRC 23-1301, A and B.
Sir, are you Randy Thompson?
Yeah.
Mr. Thompson, the state's alleging that on September the 5th at 8:32 p.m. in Union Township, you were driving a vehicle while you were under the influence of either alcohol or drugs or a combination of those things. And so this is alleged to be your first offense. On a first offense, the maximum penalty is 6 months in jail, $1,075 fine, and a 3-year license suspension. The minimum penalty is 3 days in treatment, $375 fine, 6-month license suspension. The state's also alleging that you failed to control your vehicle. That's a minor misdemeanor. Maximum penalty is $150 fine. Those are the 2 charges. Do you understand the charges?
Yes.
Do you understand the rights I explained defendants have previously?
Yeah.
Do you have any questions before you enter a plea?
No.
What plea do you wish to enter?
No, I get it.
You want a lawyer appointed to represent you?
I'll get my own.
Okay. Let's go with that October 6th date. I just set the last case. That's 4 weeks, gives you 4 weeks.
Okay.
October the 6th will be your next hearing. Be a pretrial at 10 a.m. that day. You're signing a $1,000 signature bond. As long as you come to court, you won't have to post the money. You just come to court. You're guaranteeing your own appearance.
Okay.
A not guilty plea for you. And indicate you will hire counsel. Any questions, sir?
Nope.
Okay.
State of Ohio versus Kai Grantham, case number TRC 23-1258, A and B.
And sir, are you Ty Grantham?
Yes, sir.
Mr. Mr. Grantham, it's alleged that on September 1st at 1:12 a.m., you were operating a vehicle in Fayette Township in Lawrence County under the influence of alcohol. Took a breath test and tested 14 on the breath test. The maximum penalty is 6 months in jail, $1,075 fine, 3-year license suspension. Minimum penalty, 3 days in treatment, $375 fine, 6-month license suspension. I explained the per se level of 8 previously. Were you here then, or
Yes, Your Honor.
you want me to go over that again, or do you understand?
I understand my rights, Your Honor.
You're also charged with driving outside your lane. That's a minor misdemeanor. Maximum penalty is $150 fine. So those are the 2 charges, ODI, driving outside your lane. You understand those charges?
Yes, Your Honor.
Do you have any questions before you enter a plea?
No, Your Honor.
What plea do you wish to enter?
Not guilty.
Do you wish to be considered for a court-appointed lawyer?
I'll find a
Okay. And can you do it in the 4 weeks by October the 6th, you think?
Yes, sir, Your Honor.
October the 6th at 10 a.m. That'll be your next hearing. If entered a not guilty plea for you, you can sign a $1,000 signature bond. Any questions, Mr. Grantham?
No, Your Honor.
Be back here October the 6th unless your lawyer tells you they made arrangements for a different date.
Yes, sir. Thank you.
You're welcome.
State of Ohio versus Brandon M. Ruanzu, case number TRC 23-1292, A, B, C, and D.
And sir, how do you pronounce your last name?
Brownson.
Ronson? Okay. Is he amended reads?
That's correct.
Well, this is case number 23-1292. It alleges on September 1st at 10:48 p.m. in Perry Township, you were operating a vehicle under the influence of alcohol, took a breath test and tested 11 on the breath test. Maximum penalty, 6 months in jail, $1,075 fine, 3-year license suspension. Minimum is 3 days in treatment, $375 fine, 6-month license suspension. Breath test score of 11 is over the per se level of 8. I explained that before. Do you understand that?
Yes.
You're also charged with driving 72 in a 55 zone. That's a minor misdemeanor. Maximum penalty is $150 fine. And driving outside your lane. That's a minor misdemeanor. Maximum penalty is $150 fine. You understand the 3 charges you're facing?
Yes, sir.
Any questions before entering a plea?
No,
What plea do you wish to enter?
not guilty.
Do you wish to have a lawyer appointed?
I'll get one.
Okay. So, let's see,
He's still in our residential program.
okay, but working, or
Yeah.
Yes.
you can sign a $1,000 OR bond. Set your next hearing for October the 6th for a pretrial at 10 o'clock. Not guilty plea is entered.
All right.
State of Ohio versus William Alexander, case number TRC 23-1293, A, B, and C.
Sir, are you William Alexander?
Yes, sir.
Mr. Alexander, it's alleged September the 3rd at 2:03 a.m. in Union Township, you were operating a vehicle after consuming alcohol underage. This is a section of the ODI statute, subsection. If you're under the age of 21, it's illegal in the state to consume alcohol, and you consume alcohol and drive, and you're not over the per se level, which they're saying you're not, then you can be charged with this offense. It is a fourth-degree misdemeanor. It carries a maximum penalty of 30 days in jail, $250 fine. There is a mandatory 90-day license suspension if you're found guilty. The state's alleging you took a breath test and tested 0.6, so that's below the per se level for folks that are over 21. That's 0.8, but it is, could be evidence of consuming alcohol underage and operating a motor vehicle. You're also charged with driving outside your lane. That's a minor misdemeanor. Maximum penalty is $150 fine. Do you understand the two charges filed against you?
Yes, sir.
Do you understand your rights?
Yes, sir.
How do you plead to this?
Not guilty.
You want a lawyer appointed to represent you?
Yes, sir.
Are you working?
No, sir.
You have no income?
No, sir.
Your Honor, there's also a distracted driving charge as well.
Oh, okay, thank you. I missed that. You're also charged with distracted driving. That's a minor misdemeanor. Maximum penalty is $150 fine. That's the C case, and it was on a separate complaint. So I'll appoint Mr. Stratton to represent you.
Good morning, Your Honor.
Good morning. This is William Alexander. The main charge is operating a vehicle after consuming alcohol underage. Not guilty plea is entered for him. He can sign a $1,000 OR bond. Since it's an M4, we probably need to come back pretty quick. About the 18th,
Yes, that'll work, Your Honor.
September the 18th. That's a Monday. It'll be the pretrial at 10 o'clock.
Right, thank you, Your Honor.
State of Ohio versus Vilma E. Gursley, case number TRC 23-1297, A, B, C, and D.
And are you Velma Gursley?
Gurgley?
Gurgley,
Yes.
okay.
Yes, Your
It's a hard G. Ms. Gurgley, it's alleged that on September the 2nd of this year at 4:47 a.m. in the village of South Point, you were driving a vehicle while being under the influence of alcohol. And the state's alleged this would actually be a second offense for you. So on a second offense, the maximum penalty is still 6 months in jail, but the fine goes up to $1,625 fine. It's the maximum in a 5-year license suspension. The minimum penalty on a second offense is 10 days in jail, $525 fine, a 1-year license suspension, and if the vehicle's titled to you, there's a mandatory impoundment of the vehicle. Yeah, it looks like the state is alleging that the vehicle was titled to you, so it would be subject, if you're convicted, it's subject to a 90-day impoundment of the vehicle. Your test score is alleged to be 136, we'll just call it 13, to make it easier to understand. Per se level is 8, I've talked about that some. If you have questions about what the per se level is and how that works, you understand that? The state has to show compliance with the rules for giving the test to get the attachment of presumption of impairment. You're also charged with driving on a license that had been suspended, but the suspension was over, but you never reinstated your driving privileges. And failure to reinstate driving privileges, that's an unclassified misdemeanor. Maximum penalty, 500 hours of community service, and a $1,000 fine. You're charged with not wearing your safety belt. That's a mandatory $30 fine if you're found guilty. And driving outside your lane. That's a minor misdemeanor. Maximum penalty is $150 fine. Do you understand these charges?
Yes, Your Honor.
Do you understand the rights you have?
Yes, Your Honor.
How do you want to plead to the charges?
Not guilty.
Do you wish to have a lawyer appointed to represent you?
Yes, Your Honor.
Are you working?
Yes, Your Honor.
What do you do?
I am a server at Shogun, Japanese steakhouse.
Okay. What do you make in an average week?
In a week, about 500 to 400.
Do you have do you have anybody you're supporting? You have children or anyone you're supporting?
I do not have children.
You're single?
Yes, Your Honor.
Okay. Do you know what you report? Do you report on your tax returns? Do you have you file tax returns?
I don't recall, Your Honor.
Okay. So I have to go, you're close on what you're saying, what your eligibility would be. I'm going to go ahead and provisionally appoint Mr. Steyer to represent you. You'll have to fill out a financial affidavit confirming what your income is. I'm entering a not guilty plea. She can sign a $2,000 signature bond.
Your Honor, is there any indication that the vehicle was impounded?
Yes.
Where do you live?
Actually,
Do you know anyone in Lawrence County that would allow your vehicle to be placed at their residence?
It's at Nicely's Towing.
Okay. I was hoping we might have somewhere we could have it put so that, and immobilized to avoid increasing
It'll
the
need to be an address.
storage
file.
fees, but I don't have one yet. But I'll speak to her further about that.
Okay. Looking at 25th is available in September. After that, it's going to be in October.
I'm available the 25th, Your Honor.
Okay, we'll make it September 25th for a pretrial at 10 o'clock.
Thank you.
You're welcome.
So, just wait for me to log in. I'll talk to you in a minute.
State of Ohio versus Melissa Wheeler, case number TRC 23-1295, A and B.
Ma'am, you're Melissa Wheeler.
yes, sir.
Ms. Wheeler, it's alleged that on September the 2nd at 3:22 a.m. in the village of South Point, you were driving a vehicle while being under the influence of alcohol or drugs or a combination of those things, and that you refused to take tests. States alleging that you had a prior 2010. So it's alleged, they since alleged from the states that you refused to take tests. Since there's alleged to be a refusal within 20 years, within 20 years. It's the look back period. The maximum penalty is 6 months in jail, $1,075 fine, and a 3-year license suspension. The minimum penalty is 3 days in jail and 3 days in a treatment program, $375 fine, and a 6-month license suspension. You're also charged with driving out of your lane. That's a minor misdemeanor. Maximum penalty is $150 fine. Do you understand the charge?
Yes.
Do you understand the rights you have?
Yes.
How do you wish to plead to this charge?
Not guilty.
Do you wish a lawyer appointed?
I'll file my own.
prefer a Monday or Friday?
Friday, please.
October the 6th. For a pretrial at 10 o'clock. Okay, you will hire an attorney. She can sign a $1,500 signature bond. That's all. Free to go.
State of Ohio versus Thomas G., case number CRB 23480.
You Thomas G? Yes.
How do you pronounce your last name?
What is it?
How do you pronounce your last name?
G.
G?
Yep.
And you're Thomas?
Yes.
Mr. G, it's alleged that at Rome Township on July 25th of this year, you knowingly caused or tried to cause physical harm to Emily G, and that she's either a member of your family or a member of your household. So that's a first-degree misdemeanor domestic violence charge. Maximum penalty is 6 months in jail and a $1,000 fine. You understand this charge?
Yes.
You understand your rights?
Yes.
How do you plead to the charge?
Not guilty.
You want a lawyer appointed to represent you?
I'll get one.
Is Emily here today?
No.
We have somebody from the prosecutor's office to let us know if they want a protection order.
Yes, Your Honor.
This is Thomas G. It's a arraignment on domestic violence, and if you have your file as to whether there's a protection order requested.
Your Honor, we will be requesting one, at least temporarily, until we find out more.
Mr. G, do you have a place to stay other than with Emily?
Yes.
Okay. So I'm going to order you to stay away from her, at least initially while this case is
Okay.
pending. Don't go around her, don't contact her, don't post things about her.
Okay.
Just let things calm down. So be a temporary protection order issued, you need to sign that document, take it to your lawyer. I'm letting him sign a $1,000 signature bond.
Your Honor, we would ask for him to stay long enough to sign that protection order.
Okay. Yeah, so you'll have to sign a protection order. The prosecutor's preparing that, and they'll get you a copy to take to your lawyer.
Okay.
And do you have a preference as to Mondays or Fridays for your next hearing?
Mondays.
Monday?
Yep.
Okay. September 25th. September 25th will be your next hearing. That'll be at 10 o'clock. Any questions, sir?
No.
State of Ohio versus Ron Witherell, case number TRC 164698 ABC, CRB 14844 A and B, CRB 131151.
All right, Mr. Witherall is here today,
Yes, sir.
and this looks like it's on failure to appear for review hearing 6 years ago, last October 27th, 2017. You understand that's the charge?
Yes, Your Honor.
Do you admit or deny you All right.
Oh, I'm sorry. He asked me to step in with him today. I've not been retained or anything, but I saw his paperwork, and since he had paperwork to show the court, I told him that I'd go ahead and do that for the moment, which I'm going to send this forward, certificate of discharge. He's just been released on September 1st
Okay.
from prison in the state of West Virginia.
All right, good. I'll withdraw, can we get a copy of that? I'll withdraw the warrant.
And was this a review hearing he missed, or was it a?
Reviews.
Okay.
It's on an OVI and disorderly conduct. And a resisting. So I'll just set those up for further review hearings. Do you have a preference as to Mondays or Fridays for your review hearings?
No, Your Honor.
Let's make it October 13th. That'll be a Friday at 9 o'clock. So just, you can work if you can't pay. You owe some fines, and you owe some community service. You can work it off. Fines and court costs you can work off. You got community service you're ordered to do too. But once you get that, what you're ordered to do worked off, if you want to work off the fines, you can do that too. You get $50 a day credit for every day extra that you do. Any questions?
No, Your Honor.
Okay, October 13th is your next hearing.
Thank you.
Thank you.
State of Ohio versus Sheena R. Scarberry, case number CRA 13-463, CRB 13-469, CRB 12-91, CRB 11-638, CRB 10-899.
And you're Sheena Scarberry,
Yes, sir.
and this was a missed hearing back in 2020, December 30th, 2020.
Yeah, I got extradited from here. You told me when I got done with West Virginia to come over here.
Okay, I'll withdraw the warrant. Where are you going to be living now?
I'm living in Huntington, but I've been paying on my fines and stuff too.
Okay. All right, can we get a copy of that for your file, withdraw the warrants, set you up on new review hearings, and I'll set you for October 13th also.
Is that on a Friday?
That is a Friday. Is that better?
Yes, sir. Thank you.
October 13th, 9 o'clock. What I told Mr. Woodrow applies to you too. You can work, community service, or pay, or a combination, just get your obligations taken care of.
All right, I appreciate it, sir.
So, Mr. Cooper will bring you back that document after he copies it, and then you're free to go.
All right, thank you.
You're welcome.
State of Ohio versus Sabrina D. Pettiford, case number CRB 22-104 and TRD 02-214.
Ms. Pedford was set for a review hearing Monday. She wasn't here then. She's here today on Friday,
Yeah.
and you just have to make payments. You did make the payment today, so no warrant has been issued.
Yeah.
The warrant will be issued. I'll set your next hearing for, do you prefer Mondays or Fridays?
Doesn't matter.
Okay. October 6th
Okay.
will be your next hearing at 9 o'clock.
Thank you.
You're welcome.
Won't miss it again. Thanks, Olivia.
State of Ohio versus Christy L. Jordan, case number CRA 23-549. Christy L. Jordan.
Christy Jordan. All right, she's been called for. proof of service.
I did hear them talking about, she was a passenger in the car.
All right, so they'll have to request a warrant then. There's no proof of service, these are felonies, so a warrant can issue for the arrest of Christy Jordan if the state requests it.
Your Honor, I believe Ms. Christie Jordan is in jail.
Oh, okay.
Just got a message.
All right, we'll get to her at the jail. Yeah, we didn't know that till just now, so we'll do it when we get to our jail cases.
State of Ohio versus Harold Moore, case number CRB 23-550 and TRC 23-1259, A, B, and C. Harold Moore.
Harold Moore, there is no, there's a summons, but no proof that he was ever served, at least in that first policy. He does have a traffic citation also. And he was served with it in order to be here today. That's on case number 23-1259. Is an OVI charge from the State Highway Patrol. So, on that, I will issue a KPS for his arrest since he failed to appear today to the OSP. Okay, we're going to start pre-trials now. There's some arraignments that we will do at the jail by teleconference, but we're not ready with all the paperwork yet, so we'll come back to that. We'll start the pre-trial docket now. We'll need the attorneys to come into the courtroom and any of their clients that are out in the lobby that have pre-trials need to come in.
State of Ohio versus Andrew Kelly, case number TRC 23-226, A, B, C, and D.
This was a case that had been set for pre-trial motions today, or perhaps a motion of hearing today. That's informed by counsel that there's been an agreement reached as to how to resolve it. This is a different case. It's not, we need the other one set for motion.
Your Honor, this case, there is one outstanding discovery issue that we're working through. There is a trooper who's first on the scene. We're working to obtain his audio-video recording. I have a pending motion with the court asking leave to file a suppression motion once I review that evidence. I've talked to Mr. Heald and would ask the court to set this for a pretrial on September 29.
have a jury trial that day, so that's not gonna be a good day. And I did approve your entry requesting leave to file.
Thank you.
Your Honor, that case that we have the jury trial on, we have a pretrial on it today, and there is maybe a chance that it could get resolved today, but I guess we don't know that yet.
Your Honor, Friday, October 6th works for me also.
All right, so we'll set this for pre-trial and the motion to suppress that day, is that what you're?
Yes, sir, Your Honor. Assuming I get the video, there will be a suppression motion pending at the time we appear.
Okay.
Mr. Eaches, have you talked to my assistant about making sure you get that video? Which trooper is it? It's Trooper Martin. Is the second?
He's all we need is Trooper Martin. He's the only missing video. I have the other.
Who is the other one? Oh, never mind, it's okay.
My staff will follow up with yours. You don't have to worry about it.
Okay, all right.
All right, so the pre-trial motion to suppress, which will be filed by that date at 10 o'clock on October 6th.
Thank you.
You're welcome.
State of Ohio versus Colton Landers, case number TRC 23475, A, B, and C.
Okay, so this is the case where there's been a resolution proposed to the court.
Yes, sir.
Your Honor, if it please the court, there are evidentiary issues which we addressed to the court earlier today that cause us to believe that a fair resolution to this would be an amendment of the OVI charge to a physical control. There's also an ACDA. We would be willing to dismiss the distracted driving. And on the issue of the gun charge, it's my understanding that Mr. Landers would agree to forfeit that weapon, and we would agree to nolly the charge upon the forfeiture of the weapon. And I think, is that?
It's my understanding of the agreement, Your Honor. If the court accepts that, I have identification and serial number for the firearm.
Your Honor, may I have that case number involving the firearm?
CRA 23278.
And Your Honor, this is a first offense, and the test score was, well, that's true. It's being amended. I'm sorry.
Okay, so OVI is being amended to physical control. It's my understanding of a guilty plea to that amended charge. And is that correct, Mr. Landers?
Yes, Your Honor.
Do you have anything you want to say?
No, Your Honor.
All right, I'll impose a $250 fine on the physical control court costs. Is that something you need time to pay, or can you pay it today?
I can pay it today, sir.
Okay, and then I won't impose any probation then.
Well, I mean, it's just a matter. I could just tell
The state's agreeable to, now, there was an assured clear distance ahead also.
He's going to enter a guilty plea to the ACDA, Your Honor, and the distracted driving would be dismissed.
Okay. So on the assured clear distance ahead would be a $50 fine. The distracted driving will be dismissed, and the improper handling will be dismissed on forfeiture of the firearm, and we'll need a description of that.
May I approach, Your Honor?
Yes.
Maybe it's easier to have you read it out.
Okay. It'll be ordered, forfeited, and destroyed. It is a Colt M, as in mom, 1991A1, 45 caliber. It has a serial number 2779153. Thank you, Mr. Regis. I think that's everything. Mr. Reaches, would you approach?
Yes, sir.
I meant to give you my condolences to that. I'm practicing this court. All right, that concludes this matter.
Thank you, Your Honor.
State of Ohio versus Cornelia G. Montgomery, case number CRB 23445, A and B. Tyler Smith's case.
Mr. Smith's case is set for pre-trial.
Cornelia Montgomery.
Your Honor, may I approach?
Yes. She's with the QRT.
Yes.
Okay, I have a report from Ms. McDaniel.
There's also a report here, Your Honor, from hometown.
Yes, this week.
Okay.
Okay, it looks like everything is in order, good screens, good report, QRT.
She's
satisfied?
compliant, yes.
Okay, very good. Her graduation date's in February, I think. So we can let QRT continue to supervise her when we come back shortly before the graduation date. You'll let us know if there's a problem before then, I'm assuming.
Yes, Your Honor.
Let's make it January 19th of '24.
Okay. Yeah, I'm available that day, Your Honor.
Next hearing will be January 19th, '24, be scheduled as a pretrial. Good work, keep it up.
Thank you.
You're on the right track.
All right, thank you.
You're welcome.
State of Ohio versus Dolores Hill, case number CRB 23536, Dolores Hill.
This is also Mr. Smith's case. Actually, I think we're doing a motion to drop the protection order. Are you Miss Smith? Okay, so you're the alleged victim in this domestic violence, but you're wanting the court to drop the protection order, is that correct?
Yeah, so she can come home and live with me.
Okay. State have any objection to that?
We do not have an objection. The only thing is we will need to get the file and everything so we can do the order.
Okay.
And her name is?
Lou Ann Smith.
Oh, okay. What's the name of the defendant, Your Honor?
The defendant is Dolores Hill.
Okay.
It's set for a hearing September 25th as pretrial.
She was just arraigned on Tuesday.
Okay. And you're her mother, is that correct?
Yes.
All right. At your request, ma'am, the protection order is dropped.
Thank you so much.
You're welcome. Good luck to you.
Yep.
State of Ohio versus Renee Bledsoe, case number CRB 23473, CRB 23475.
Stratton's case, that's what they're on.
Yeah, Your Honor, this is a first pretrial. I think the prosecutor wants to, had no contact with the alleged victim in this case and wanted to.
What's the name? I'm sorry.
What's the?
Yeah, that's the one. The victim was arrested too. Dismissed his charge name.
He's the one that's maybe his restitution, but we haven't got hold of him. Your Honor, at the time that this occurred, the alleged victim in this matter was also a defendant. There was a disorderly conduct charge, and Ms. Bledsoe's charge was disorderly conduct, but also a criminal damaging charge. And we would be most, of course, compelled to go forward with the criminal damaging charge, but we have not been able to have contact with Mr. McGuffin. So he hasn't made an attempt to come forward to us. There's probably something that we're going to need to nolly this with the right to refile it if he comes forward.
Did he ever appear for his, was he charged also then?
He was charged with disorderly conduct, and it was dismissed at the arraignment.
Okay.
And that was just based on what was alleged. So we do have a number for him, but but the voicemail isn't set up, so you can't leave a message for him, and he hasn't responded. So I guess our other alternative would be to subpoena him. Maybe we should do that, if we could ask to first some time.
First hearing.
Yeah.
How long do you think that would take?
Yeah, at least 2 weeks, Your Honor.
About the 25th, and then are you available then, Mr. Stratton?
Yes, Your Honor.
Ms. Bledsoe, September 25th? All right, September 25th will be the next hearing. Expect the complaining party to be present, and it will be acknowledged then at that point if he is not cooperative or doesn't appear.
All right. Thank you, Your Honor.
State of Ohio versus Lee, case number CRB 23-211, CRB 21-942.
Mr. Stratton's case.
$100. Your Honor, he'll pay $100 on Monday. It's just us coming back for payments.
Well, there's two files here. There's one that looks like he's been making payments on, and there's a current charge, 23-211.
It has been since on either one, but it looks like it's became restitution under 41.
Yeah, that's what. Yeah, that's what we've
Longer
been
sentencing.
coming back, just paying restitution is all we've been doing.
On the other charge, Your Honor, the victim, this case is a violation of protection order, which was a civil protection order, and the alleged victim went to the court, common pleas court, to try to get the protection order dismissed, and because it expires in September, the court declined to dismiss it, but she wants it dismissed. She wants Mr. Kipp to finish his treatment. Now, back in May, he was at New Beginnings, so I don't know what the status of that is. Still
The
there?
last report that I have was from Emily Boggs.
Yes.
And it's a new behavioral health. Emily Boggs is going to write this report. That's been some time ago.
Yeah, he's completed everything, Your Honor. We've been back several times on these cases. Last time was July 31st. It's merely just a payment of restitution is what we're coming back on payments on. So that's all we've been doing.
I did the anger management.
Yeah, we've done all that way back in the past.
Yes, sir.
you know how
Well,
much.
I don't have a report from Anu saying he completed. I have a report saying he was engaging in treatment and is compliant, but it doesn't say he was completed.
Your Honor, I have to look back through my notes. I know there was a time when we addressed all these issues.
If he has, and he brings, I mean, he's going to need to come back anyway to finish paying the
It was all,
restitution.
yes, sir, it was all voluntary. My time in the new was all voluntary.
Yeah, it wasn't-
Yeah, it wasn't a
Right.
court, no drug
Okay.
involved case or anything like that. But yeah, I can get you a report. Okay.
Your Honor, I can reach out to Emily. She actually works through our facility real quick if you want.
Okay.
How much was the payment today?
I'll make $100 Monday.
We'll make $100 payment Monday.
So our goal eventually, assuming that there's not going to be any further reason to keep the case open, that would be to dismiss the charge with the payment of court costs. And we would like to see something from a new behavioral to say that he's been successful in his treatment there.
Just get a letter.
Yes, sir. Yes, sir, not a problem.
October 6th is the next hearing.
Yes, that's fine, Your Honor. October 6th.
State of Ohio versus William LaSalle, case number CRB 23452.
Straps case,
We have I didn't have a printed copy of the document. I've got it on my phone.
Okay.
I was just gonna ask you whether you got it or not. I had them mail it to your office.
So last time we were here, Your Honor, we agreed that we would go to PATH. We do have a letter here.
I say, it doesn't make any sense.
It does say he's not in need of anger management.
Sure.
Your Honor, do you want to see it, or is it?
Not if the state's satisfied.
Okay. Now, hold on.
If Miss Terry LaSalle, is Terry LaSalle here?
She's not here. She went to.
It would be important for us to hear from her on this too. The report says that he's not in need of those services. Ms. LaSalle says there have been no issues, so that was as of just day before yesterday. Typically, we're going to do at least a 90-day continuance, and I don't believe we've gotten there yet. So what we would like to do is come back one more time, and that way we have time to consult with Ms. LaSalle and see if she agrees with the assessment. I realize she's not a mental health professional, but she is Mr. LaSalle's spouse. And that would clear the way for us to make a decision as to whether we can dismiss the charges at a later date with the payment of court costs.
Mr. Strzok.
Yeah, Your Honor, that's fine. We can come back one more time, and there will be no issues. There hasn't been any issues, and maybe if she's okay with it, we can get rid of this case.
October 13th.
October 13th, yes, Your Honor.
And Sean, could you can you print that off?
Yes, yes, October 13th. Thank you, Your Honor.
Well,
State of Ohio versus Laban K. Murray, case number CRB 23-412, A, B, and C. Laban Murray.
Mr. Stratton's case, this is the one set for
Trial.
trial on the 29th.
Yes.
Claudia Crank.
Claudia out of the hallway.
She's here.
She's on.
Yeah, she's on board.
So, Your Honor, I want to take the opportunity to speak with her for a few moments today, and I don't know whether that's something that can happen right this minute or not. The intention of this pretrial today was to have the opportunity to address some things before we go forward. She's here.
You want to have it recalled then, or?
Yes, but I don't know to what extent I'm going to have time to talk with her, is the only thing.
At the end of the docket, of course, perhaps.
Yeah, Your Honor. I think we have a resolution, maybe. I think prosecutor can probably just speak to her right there, and we'll resolve it. That's better.
Your Honor, I've spoken with Ms. Crank, who is the alleged victim in this matter, and she is the co-parent of at least one child together. And this happened in the context of their home life, and the child was close by, and there were several things about it which were, as far as the reports go, were concerning to us. After we have had an opportunity to thoroughly determine what Ms. Crank's feelings are and what we can prove and maybe not prove and things of that nature, we are willing to offer Mr. Murray today that we would present to the court, if he were to plead guilty, a suspended jail sentence of 6 months. Will be suspended. She didn't want a protection order. They've been at least working on their relationship. And an understanding that if there is another situation like this that arises, that not only would we charge it as a felony and he would risk going to prison, we would have 6 months in jail here that we would seek to impose upon him. So Ms. Crank is satisfied with that, and I think under the circumstances that it suits probably the interests of justice.
Your Honor, I believe in our conversations, Mr. Hill, that you were talking about pleading to the domestic violence, correct?
Domestic violence, yes.
Okay. Your Honor, will plead guilty to the domestic violence, ask for suspended time, and ask that the other charges be dismissed.
Okay. So we've got the domestic violence is 23-412B. Make sure I've got all the terms. The 412A was endangering children, so if there is a plea to the B case, the state's going to dismiss that.
Yes, Your Honor.
And then there was a C case also. C was obstructing official business, so that will be also dismissed.
Yes, Your Honor.
Yes, Your Honor.
That's the defendant's understanding also.
Yes, it is.
Okay. All right, so Mr. Murray, your attorney says you wish to change your plea to the domestic violence charge. That's case number 23-412. That's allegedly happened July 6th of this year. To guilty, is that correct, sir?
Yes, sir.
All right. You have a right to make a statement, but before you do that, also the complaining party has the right to make a statement, so we probably should hear from her first, and then if you want to respond, you can. And I understand, ma'am, you're Claudia?
Yes.
Claudia Crank? And you you have some sort of relationship with Mr. Murray? You had a child together?
Yes.
But you don't have a romantic relationship any longer?
Yes.
Or you do have it?
Yes, we did.
Oh, you're still together? All right. You have a right to make a statement to the court if you wish as the complaining parties, or anything you want me to know about this? Okay. All right, Mr. Murray, do you have any statements you want to make?
No, sir.
Okay. Well, I also want to make sure before I finalize this, you understand there's a few types of charges that are progressive in nature, and that means if you get a conviction on one, then the next time you get a charge, the sentence can be escalated because of the prior conviction. This is one of those offenses. You could be subject to a felony charge if you get a similar charge in the future. Do you understand that?
Yes, sir.
And you're still willing to enter this plea?
Yes, sir.
All right, I'll accept your guilty plea. I want to read the affidavit before I make a sentencing decision.
Your voicemail still not set up. Okay, so we really know where you're going.
Well, after this affidavit is correct, this is a very serious situation. What I would like to do is delay the sentencing, and I want to refer Mr. Murray, and Ms. Crank wants to go voluntarily since they're continuing their relationship. I think there needs to be some intervention with counseling. I don't want to see something similar to this event occur in the future. So I think there needs to be some sort of intervention.
What kind of
Counseling.
counseling?
How do you pay for medical services, Mr. Murray?
I pay out of pocket for everything for myself.
You don't have a credit card?
No, sir, I do not.
Are you working?
I was, but I have quit recently
Okay,
due
so
to,
you may be eligible for a medical card at this point. And you're both Ohio residents,
yes, sir.
correct?
No, I live in West Virginia.
Do you live in West Virginia now? Has that changed since this incident occurred, or?
I live still
what address you all should have on file is the West Virginia address I have. I've lived over there since actually the situation happened in July.
They were at her sister's residence when this happened.
Okay. Do you have a West Virginia medical card?
No,
Are you working?
no,
How do you pay for medical services?
everything is out of pocket.
Okay. Do you plan to stay in West Virginia?
Yes,
So you are not going to be living together in the future, or?
uncertain, I guess. I'm not really sure where things are going at the moment.
Okay. I'm going to make it as hard as possible to get this done.
Does OVP offer that kind of service?
I'm not sure. Brianna was
What is
here.
it? I'm sorry, I didn't even hear what you're asking.
We need some sort of counseling for, there's no indication of substance use issues, but anger management, pretty violent situation.
No, we offer like family counseling and stuff through the recovery center, but I don't believe they do it in outpatient.
Okay, so it has to be inpatient.
Yeah.
I'm doing your management outpatient.
All right, would you willingly, I can't order you, ma'am, to participate, but I think it's a good idea. You're going to have a relationship, and you got a child, at least one, or more children?
We have 3.
3. So you're going to be around each other regardless. So I don't want to see this happen again. And Taylor, you need to take a look at the affidavit too.
Yes.
Just to make sure they give you the straight story. Pretty serious stuff involving a gun. So I'm going to delay sentencing, let you go get something set up with Taylor for counseling, and if it doesn't work out, then let's come back, talk to her. If she can't get something set up, then come back in, we'll try to go a different route. Otherwise, I'm going to see you back and say, well, let's keep that 29th date when we're going to have a trial. We'll make that a sentencing hearing at 10 o'clock.
And are the other 2 charges not leaked today, or are they delayed as well?
I'm just going to hold them in abeyance. My plan will be, to hopefully dismiss them, but I'm not going to dismiss them at this point. So
Yes, sir.
I want to see this taken care of so nothing like this ever happens again. Not acceptable.
So go talk to the lady in the hallway, okay?
Okay, September 29th, go talk to Taylor. She's out in the lobby.
Thank you, Your Honor.
State of Ohio versus Joseph Brazos, case number TRC 23999, A, B, and C.
This is Mr. Each's case set for pretrial today.
Your Honor, I've talked to Mr. Hill about this case. We had some mix-up with the initial discovery disclosure. That has been fixed now, Your Honor. I have a motion to allow me to file a suppression motion. I intend to have it filed by Monday. It's one of my projects for the weekend. I would ask the court to allow us to pretrial this case again on October 6th.
Okay, I've approved your entry in the case.
Thank you.
Will be scheduled for another pretrial, and that'll be a pretrial on the motion.
Yes, sir.
Pretrial motion to suppress, 10 o'clock, October 6th.
Thank you.
You're welcome. Okay, we're going to go to the jail now for some arraignments and pretrials.
State of Ohio versus Joseph Atkins at Lawrence County Jail, case number CRA 23260, CRB 23261, PRD 182412.
Okay, this was set for a bond forfeiture hearing today. Mr. Sowers is here, and this was Roger Smith's case.
It is, Your Honor, but he's out of town today, so I'm stepping in for him.
And this was an active case with preliminary hearing. And pre-trials, and it looks like he has failed to appear July 31st, or July 3rd. July 3rd, it looks like. And had a warrant, or had a bond up, and then Mr. Sowers, you were on the bond, and you secured his body to be at the jail, or?
Somewhat, yes. He had moved from, had no affiliation with any of the addresses I had on file. I knew he'd moved to Huntington, so I was searching multiple residences in Huntington. I did pass his information on to several Huntington police officers, and they spotted him one day and picked him up and secured him into the Western Regional Jail on our behalf. I think they had charges that they filed as well, but I think he's resolved those charges now, and he was just transported back over here this week.
Okay. Mr. Smith, have you had an opportunity to speak with Mr. Atkins? Or?
I haven't, Your Honor. I did talk with his counsel.
In Campbell County, you're talking about?
No, with Roger Smith here about, one, trying to get a new date set, but also maybe trying to, I don't know if Mr. Sowers is going to remain on the bond or you're asking to be off the bond.
I'm asking to be released.
Okay, and if that's the case, I've talked with Mr. Hill maybe of setting a new date, but also maybe if Mr. Atkins is amenable to it, and I can call down there if he wants to talk about more, but possibly going into, because I believe there's a felony for possession.
And two separate
Theft cases. Maybe a possibility of doing treatment and GPS monitor as part of the new bond, but I can talk to Mr. Atkins if that needs to be done.
All right, so I think what we'll need to do, I'm going to release Mr. Sowers from the bond. Unless Mr. Atkins has some compelling reason he thinks he should be released.
No, sir. I wasn't trying to not show up. My vehicle broke down.
Well, you had quite a bit of time you could have got here though before now, so that didn't happen.
My vehicle still broke down.
Well, that's not an excuse not to come to court.
No, I know that.
All right, so Mr. Sowers is released. I'm going to recall this. I'm going to let, your attorney is out of town today, but his brother happens to be an attorney and practicing in his court. He's here today, so he's going to cover for Roger, call and talk to you, and then we'll recall this after that's happened.
That's fine, Your Honor. Thank you.
State of Ohio versus John Cronin, case number CRB 23244 A and D, PRC 23431 A, B, C, D, and E. Richard Lovell is on deck.
All right, John Cronin is Mr. Morford's case. And this is set for a pretrial today, and we are looking for your results today.
We are, Your Honor, and this is a case that, I guess back on May the 5th, that Mr. Cronin did not appear before the court, and I don't know if he was here. I don't think he was here until today.
Well, he got arraigned.
On
He got
first.
picked up on a warrant.
Yeah.
Arraigned, and I said
So he's been in jail for a week
can't do
now.
bond. He's been in jail. He hasn't been able to post bond.
So what I would need to do is find out what, I would assume that the results are back now
Should
because
be,
it's
it's
in
an
April.
April case.
So we can do that if the case can be recalled.
All right, this case will be recalled later in the docket and get the prosecutor to find out. come back to Mr. Cronin later.
State of Ohio versus Robert C. Lovell, case number CRV 22672. Jeffrey Spears is on deck.
Sir, are you Robert C. Lovell?
Yes, sir.
Okay, as I think you know, Judge Capper, this is a arraignment on a failure to appear. You had this case in my court that you ordered to appear for on November 14th of 2022. It's on charge of domestic violence. It's alleged you did not appear, got a warrant issued because of your failure to appear, and it looks like you got arrested on the warrant. Do you understand that charge?
Yes, sir. Yeah, my mother lost her husband of 20 years, and I was in South Carolina for her. I apologize for that. She's been very bad, Stacy stories. So I guess I do apologize. I've never this story before. And I have been locked up for 40 days now. Lost my job and everything. I'm hoping to be able to get back to society. I'm not a drug user or nothing like that, but yes, sir. I apologize.
Well, your attorney's Mr. Thompson. He's not here today. Of course, he didn't know you would be arrested and would be in jail. So what I'm going to do, I had previously let you out on OR bond, so I can't do that now. It's going to be a $2,000 cash or surety bond. Is that a bond you think you could post?
No, sir. There's no way.
Okay, well, I'll put you back on the docket then for Monday, September the 11th. I think Mr. Thompson will likely be here then for a pretrial. So you'll have a chance to talk with him then. We'll decide how we're going to proceed. You know if he's going to be here.
You want me to approach first?
Yeah. I'll disappoint you. All right, Mr. Lovell, what I'm going to do, I just talked with another attorney who has somewhat of a relationship with Mr. Thompson. He's afraid that he has some medical issues and may not be available Monday. So what I'm going to do, I'm going to go ahead and appoint you a new lawyer. I'm assuming you haven't been working if you've been in custody for 40-some days. So I'll appoint Mr. Stratton as your lawyer now. Let him call down and talk to you. And are you here Monday?
Yes, I'm here Monday, yes.
Okay. I'll put it on the docket for Monday. If you think it can be resolved before then, you can let the bailiff know, we'll recall it. But the bond will be for Mr. Lovell now, $2,000 cash assured. Okay. You can have a court stop.
State of Ohio versus Jeffrey Spears, case number CRA 23547. And Michael Tracy is on deck.
Sir, are you Jeffrey Spears? Mr. Spears, I'm Judge Capper at the Lawrence County Municipal Court, and it's alleged that there's a warrant for your arrest issued by the Athens County Common Pleas Court in case number 23CR12 and 23CR50 on felony charges of tampering with evidence and possession of a fentanyl-related compound. And it looks like there's also some sort of theft offense. So you have a right to have a hearing in this court. It's called a Rule 4 hearing to determine if you are the Jeffrey Spears being sought by Athens County, and if I should order you to go there on these charges. You have a right to have an attorney appointed if you can't afford one. But it will not be on whether you did or didn't commit those offenses. It'll be whether you're the person they're seeking and if I should order you to go to that jurisdiction. You can waive that if you want and agree to go to Athens County, or you can have an attorney and have a hearing here on that issue. How do you want to proceed? Do you want to have an attorney represent you on the Rule 4? You do? Do you have a job?
We're trying to rehab.
Okay, so you have no income right now. I'll appoint Mr. Morford to represent you. Let him call down and talk to you. And maybe we recall this and resolve it later in the docket today. So we'll recall it regardless. I'll give you the file. It's on a warrant out of Common Police Court in Athens County on felonies. Okay. So Mr. Morford will be your lawyer. He's going to call and talk to you. We'll recall you after that's happened. Thanks, Judge.
State of Ohio versus Michael H. Tracy, case number CRB 23548. And Christy L. Jordan is on deck.
Hello, sir.
Are you, sir, are you Michael H. Tracy?
Yes, sir.
I'm Judge Capper at the Lawrence County Municipal Court. This is a arraignment hearing for you. We're doing it by teleconference, obviously, so you are appearing in the court today by teleconference, and your image is in the courtroom on a monitor. It's all being recorded, so you have a right to remain silent. You don't have to make any statements. If you choose to make statements, they can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state prove this charge beyond a reasonable doubt. You know, do you understand those rights I just explained to you? The charge filed against you is domestic violence. It alleges that at Rome Township, September the 8th, 2023, you knowingly caused or tried to cause physical harm to Hannah Campbell, and that Hannah is either a member of your family or lives in your household. Do you understand the charge?
Yes, sir. I understand.
And do you have any questions before you enter a plea to this charge? You can plead guilty, not guilty, or no contest. Those are your three choices.
Truthfully, sir, the whole fight got into it was too big. So I guess I'll plead guilty, sir.
If you plead guilty to this offense, you're waiving the rights to have a trial, to have a lawyer, to make the state prove this charge.
Never mind, my bad. My bad. I actually have a trial.
Okay. I'll enter a not guilty plea for you. Do you wish to be considered for a court-appointed lawyer?
I court-appointed lawyer, yes, sir.
Are you working?
Am I working? Yes. I was hoping to get there about 3 o'clock today, but I don't think I'll be able to make it, sir.
Where do you work?
I work at the Delta Hotel in Barbersville.
Are you paid by the hour?
Yes, sir.
How much?
$10 an hour.
Okay, you're eligible for court-appointed counsel then. Mr. Smith, I'll appoint you. Your attorney's in the courtroom. He's heard the proceedings so far. It's a domestic violence charge. Is there a protection order requested?
Yes, Your Honor.
Okay. The complaining party's name is Hannah Campbell. Do you have a place to live other than with Hannah?
I can make I can make something work. If I can just get to my house, get clothes and stuff, and just get my car, I'll be fine.
Okay, does she
And I'll be able
live,
to do court and everything.
does she live at your house?
Yes, she does.
Do you have children?
No, we do not.
Okay. I'm going to release you with the understanding you're ordered to stay away from her, not go around her or contact her. And that includes, you can't go get your stuff. If you can get a third party to go get it, that's fine, but I don't want
I was gonna ask if I could have an officer, like, take me there, I'll just grab real quick, and leave with the officer there.
No, I mean, you can ask, but they always say no, they've got too much other stuff to do, so. No, you can get a third party, go between, if there's somebody in between you and her, they can go get your stuff, fine. I don't want any arguments or breach of the peace. And if you can't get it, you just have to wait and come back to court. So I guess maybe we need to come back pretty quickly then.
It's fine.
My grandfather owns the house that she lives in, sir, so I could probably just ask him if he can grab my stuff, take it to his side of the house, and just hand it to me to the garage door. Would that be possible?
Well, you gotta stay 500 feet away.
Is it okay if I just ask him to see if he can meet me somewhere?
Yeah, that's fine, that's fine, as long as there's not a breach of the peace and I don't want there to be another incident and somebody get hurt, so.
Yes, sir.
Let things
Yes,
calm
sir.
down.
But, is there any way I can get my car so I can go to work? My car is there.
Yeah, if you can get your grandfather to get it, or somebody that's not gonna breach the peace to get it.
I don't know, sir. Yes, sir. I'll make it work. Yes, sir.
Next Friday.
That's fine, Your Honor.
Okay, I'm gonna order you into court. I'm gonna let you out on your signature bond of $1,000.
Yes, sir.
So you're promising to come to court. You gotta be at the court in Chesapeake next Friday at 10 a.m. Do you know where the court is in Chesapeake?
Yes, sir, I do.
Okay, and Mr. Smith wants a phone number where he can reach you.
The best phone number to reach me would be 740-886-0236, and then I can give you a secondary number, which is 681-347-1940.
Whose numbers are those?
The first number would be the quickest way to get hold of me, that is my grandfather.
What's his
And
name?
the second one,
What's your
James
name?
Brister.
James Brister or Brewster?
Brister, B-R-I-S-T-E-R.
Okay. And the second number?
It's my number. I've kind of lost my phone and everything going on. I will try to find it. I'll ask him if he can look for it and give it to me.
Okay. All right, your next hearing is September the 15th. I'm entering an order for you to stay away from Hannah. It'll be faxed down. It's called a protection order. You'll have to sign that.
Yes, sir.
Your attorney's name is Tyler Smith.
Yes, sir.
$1,000 OR loan. Any questions, Mr. Tracy?
Other than, I just gotta call somebody to come pick me up. I mean, other than that, I'm good.
Okay. All right. Next Friday, 10 o'clock, you gotta be in court in Chesapeake.
Next Friday at 10 o'clock, I got to court Chesapeake. I'll write that down on this paperwork that they have here.
Okay, that's all.
Thank you, Your Honor.
State of Ohio versus Christy L. Jordan, case number CRA 23549. Joseph Atkins is on deck.
Ma'am, are you Christy Jordan?
Yes, sir, I am.
Okay, Ms. Jordan, I'm Judge Capper at the Lawrence County Municipal Court. This is your arraignment hearing occurring in the court by teleconference. It's all being recorded, including the audio and video. You have a right to remain silent. You don't have to make any statements, but if you do, it can be used against you. You have a right to have an attorney.
Sorry.
Did you hear what I was telling you?
Yes, sir, I did.
You have a right to have an attorney, to have one appointed, if you can't afford one, to have bail, and to make the state prove you only have one charge. They have to prove this charge beyond a reasonable doubt. Do you understand those things?
Yes, sir, I do.
You're charged with possession of cocaine. It's a felony of the 5th degree. It's alleged this happened on September 2nd, 2023 in Terry Township. that you knowingly were in possession of cocaine. That's a Schedule II substance. The maximum penalty for this is a year in jail, $2,500 fine. Do you understand the charge?
I understand the charge. What did you say about the bond?
I haven't said anything about a bond yet.
Oh, it's just really hard hearing.
Oh, I do. It's just not marked on the outside of the phone. Okay, you have a misdemeanor charge also. 23,551. And it alleges that at the same time and place, I think maybe the complaint left some stuff out, but the affidavit looks like, the allegation is that you have buprenorphine strips without a prescription. So that's a misdemeanor offense.
No, I think you got the wrong girl. That's not me. I never, you guys got the wrong person.
Okay, well,
I ain't never had no Suboxone on me or nothing. I don't get prescribed that, nothing like that. You guys got the wrong person, I'm telling you.
okay.
Are you sure my name's on that?
I'm looking right at it. It says Christy L. Jordan. Prescott.
I didn't break no Suboxone in here.
Okay, ma'am, look back at me. This is what the state's, okay, hold on. The state is alleging this. They have to prove it. They may not be able to prove it. You're saying it's not true. Fine, but you need to understand what they're alleging. It could be a mistake.
Okay. Yeah, it's a mistake.
It's a misdemeanor. The other is much more serious. It's a felony. So, do you have the money to hire a lawyer?
Not at the time, sir.
You have a job?
I'm on disability, so.
That's your only answer? Is Social Security?
Yeah.
Okay, you're eligible for
Yeah.
court-appointed counsel. Then, I'll appoint Mr. Steyer to represent you. So your lawyer, I believe, is still here, so we'll get him in the courtroom, bring him up to speed, and decide bond and those sorts of issues. Need Mr. Steyer in the courtroom?
They just gave me a PR bond 2 days ago, so that I can leave here to go to treatment.
She's got a case in Ironton Municipal Court, I believe.
She has charges in our municipal also.
Well, I believe she does, but I just looked it up and I didn't see, I don't see it on here, but I'm thinking maybe they've spelled Christie differently, or maybe. Did they?
Yep, they did. They spelled my name wrong in court the other day, too.
How
I told them how to spell it.
How did they spell it?
My name is spelled Kristieleejordan.
Do they spell it Christie like Christy?
They got the wrong, yeah, that's the wrong person.
Well, is that how they spelled it in Ironton?
Nope, they spelled it in Ironton,
Okay.
Kristieleejordan.
Okay, Mr. Steyer, I'm going to appoint you to represent Ms. Jordan. She has a possession of cocaine charge, felony 5, and a misdemeanor possession charge.
I've been advised that, I guess, ARC assessed her for John Kincaid and Ironton, but is unable to take her. Where does she live?
Michigan is the address
I live in Louisa,
Kentucky?
Kentucky.
Do you have a Kentucky medical card?
Yes, sir, I do.
I'm trying to work with OVP to get her in detox and stabilize, and then we can take her. I'm still waiting to hear back from OVP. They're supposed to call me any minute.
I can call them and see what's going on.
Okay, well, why don't we do this? I think it'd be probably smart to let you talk with her and let them make some phone calls on what's happening, and then come back and finalize.
Yeah, that would be what I'd ask to do, Your Honor. Please.
Okay, your attorney's going to call and talk to you, ma'am, on the phone, and after that, we'll have you back on teleconference.
All right, sounds good, Your Honor.
State of Ohio versus Joseph Atkins on recall, case number CRA 23260. CRB 23-261, and TRD 18-2412. Robert Lovell is on deck.
All right, Joseph Atkins is back before the court. Mr. Smith, you had a chance to talk with him?
I did, Your Honor. As you're aware, that this is Roger Smith's case, but I did talk with Mr. Atkins, I believe, and also with Mr. Hield. I think what we can work out if the court approves is to get him into treatment somewhere. He's a West Virginia resident, has a West Virginia medical card. He also is willing to plead to the 2 misdemeanor theft charges. I'm not sure if there's restitution or not owed on any of it, but he's been in jail for a while. I believe that the state recommends just credit the time served on the theft charges. There's still an F4 possession, so that's what the treatment to go to. And if GPS needs to be added to it, he's willing to do the GPS as well. I don't know. He's been to Pinecrest before in West Virginia. I don't know if that's one the court recognizes or if he needs to go to another West Virginia or someone that can take the West Virginia medical card.
Heather, you want to talk with him about inpatient and
What kind of insurance? Just West Virginia Medicaid?
West Virginia Medicaid, is what I understand. Is that correct?
Mr. Atkins? Okay.
Okay. So let's let that happen. Do you know how to get in touch with the jail to talk with him? Somebody help her with that. And Mr. Smith, consult with him, and then we'll come back after that's happened. So I'm going to let you talk to a counselor about getting treatment, and then we'll come back and decide how we're going to finalize this. It will be recalled later in the time.
Thank you.
You're welcome.
State of Ohio versus Robert C. Lovell, on recall, case number CRB 22672. John Cronin is on deck.
Your Honor, we spoke to the prosecutor about this issue, spoke to Mr. Lovell. We are going to enter a plea of guilty to the domestic violence, ask that it be set for sentencing, and I think the prosecution's recommendation is that he'll be given a signature bond until sentencing.
Okay.
There is a protection order that was issued back in October of '22, so we assume that would stay in place. We haven't had the opportunity to speak with the alleged victim since way back then. We're going to want to catch up with her, and I don't know how many days Mr. Lovell has spent in jail here recently, or how much of that should be considered for purposes of a sentence. I'm sorry. Well, we want to find these things out, and this is one we'll know a lot more after we have a chance to find out what has happened since he was here last.
He has approximately 40 days in.
Where was he? Not at the jail.
This is 9/6/23.
Was he in Western Regional, or where was he?
Mr. Lovell, where else were you? I'm sorry, Your Honor, I should have asked that question on the phone.
I was in Middleport, and then I was extradited here.
So he must have had some other charge.
So that's where the bulk of your time was in Middleport then?
Judge, we're going to go ahead and try to reach the young lady who's the alleged, the victim in this case, to make sure we don't have some lingering issue that we need to be concerned about.
So we'll need to recall in Mr. Lovell's case. We're going to let the prosecutor try to get in touch with the complaining party, Mr. Lovell, and we'll call you after that happens.
All right, thank you, sir.
State of Ohio versus John Cronin on a recall, case number CRB 23244 A and B, PRC 23431 A, B, C, D, and E.
Mr. Morford in the courtroom. state was looking for hearing results.
It's not back yet. I've got Mr. McClellan working on that at the prosecutor's
Okay,
office.
well, we don't need Mr. Cronin then. We're not ready for him. Okay, we're not ready for Mr. Cronin yet. We don't have the results, so that finishes us up at the jail for a while. We'll be
Judge?
coming back to the jail. What?
I do have Mr. Spears if you want to talk with him from the jail.
Okay, you have Ronald Spears out. Is it Ronald? You've got his folder?
My approach?
Yes.
Yes, Judge, he's willing to waive extradition to Athens County.
It's Jeffrey Spears, not Ronald Spears. Jeffrey Spears. Case number is 23547. So if you've got Jeffrey Spears, we can recall him. Okay, let's go to one here while we're waiting. We obviously don't have Jeffrey Spears out.
State of Ohio versus Sean DeWeese, case number CRB 22637, A and B.
This is Mr. Morford's case set for pretrial. Sean DeWeese. Sean DeWeese has been called for. Have you heard anything from him, Mr. Morford? Have you heard anything from Sean DeWeese?
I have not, Judge. Last I had was when we were here in July, had a good report from Pathways.
Okay, he has appeared today, so there'll be a bench warrant issued in 7 days.
Thanks, Judge.
Now, Mr. Spears is on the camera now. Jeffrey Spears, case number 23547. Mr. Morford.
Judge, I've had an opportunity to talk to Mr. Spears. He is willing to waive extradition to Athens County.
Is that correct, Mr. Spears? You're willing to go to Athens voluntarily? Okay, you don't seem very happy about it, but I heard a yes. I'm going to set bond at $15,000. These are serious charges. And I'm assuming that's a bond you cannot post.
Oh, is it?
No, he answered. So Athens County needs to be notified that he's available. Immediately, and I'll give them a week to pick him up. So that's, let's put him on the docket for next Friday. So that's the 15th. They have to do that before 8 a.m. Or be on this, he's still in the jail next Friday. I want to see him next Friday at 10 a.m. So, Mr. Spears, a form is going to be sent to you to sign to waive your right to a hearing about going to Athens, which I understand you want to do, because you would just be sitting here waiting on a hearing, and then probably eventually you're going to go to Athens anyway, so this delays the inevitable. So, any questions, sir? Okay, that's all.
Thank you, Judge.
Hey, Butch. We have Cronin now, Your Honor, the results.
Okay, we can do Cronin, John Cronin.
Did you get a copy of the report, Judge?
I didn't, but the prosecutor says they have. This is your case, Mr. Morton.
Yes.
All right, Mr. Cronin is on the screen now. State have the results back.
Yes, Your Honor, and I've handed the copy that I have over to Mr. Morford, and probably the court wants to look at it too. Was positive for several things.
Thank you, Judge.
Okay, I've got report from the lab, State Department of Public Safety. Cocaine metabolite was positive, methamphetamine positive, amphetamine positive, norfentanyl positive, and fentanyl positive. So how does Mr. Cronin wish to proceed, Mr. Morford?
Well, if you plead guilty, I think he's done about 7, I don't know how many days in jail, at least 7, with a total of 15 days. And that would also include the misuse of the car, the unauthorized use of the vehicle. The unauthorized use, the paraphernalia, and the OVI. So 60 days with 15. He served 15. 45 suspended.
Mr. Cronin, the prosecutor has extended an offer to you to decide whether or not you would accept it, and then we'd ask the court if the court would accept it. Do you want me to call you and tell you what you tested positive for?
Okay, we'll recall this later in the docket after Mr. Morford has consulted with Mr. Cronin.
I'd really like to talk to him, Judge, before we do.
And I want you to also relate to him, I mean, I'm probably not going to let him out on just a jail sentence. Fentanyl is like playing Russian roulette. He needs to go to treatment.
Understood.
So that would be my prayer. It's either going to be a high jail sentence, you can just sit in jail if you don't want to go to treatment, or go to treatment.
Okay. Let me find out what his pleasure is. Thank you, Judge.
You're welcome.
State of Ohio versus Jason McCoy, case number CRB 23537. Companion case, State of Ohio versus Eric McCoy, case number CRB 23534.
No. Delato's your attorney, right, Karen?
But the lawyer's not available to make it here.
He's not?
No.
Okay.
That's what I was supposed to be waiting to tell him.
All right, so Mr. Stratton, you're representing Aaron McCoy, Mr. Jason McCoy. You said you were going to hire Mr. Delauder today.
Delauder's already hired, but he was not available to make it here. I've not been able to get in touch with him. He's been out of town, and then he's got some case over in Kentucky today. He told me to let you know that I need to get a continuance. He said wait to be called up and ask the court for a continuance.
All right. Counsel, what's your position?
Your Honor, the last time that we were here, there was some indication that there were children involved in this situation, so we contacted Children's Services, and I haven't heard anything more, but I assume they've taken action in some form. We also learned that there had been prior Children's Services involvement, maybe in West Virginia, or maybe here in Lawrence County.
It was Ohio.
So that's a real major concern for us. I assume these two individuals are married, and they both are charged with domestic violence. Our goal is to make them calm down and quit hitting each other, or whatever they're doing. We would like for them to attend to some counseling. We would be agreeable to continuing the case. I'm assuming that if Children's Services is involved to the extent that they are requiring them to do something to get the kids back, that counseling is going to be part of it. I don't know, but do they have the children? Does somebody else have the children?
No, she has the children.
You do? Did Children's Services come and see you?
Not yet.
Okay. Well, we told
And the
them.
first case of CPS was all cleared also.
Okay. You'll have to leave it to Children's Services to do what they feel needs to be done, but nonetheless, we think that there needs to be some anger management, marriage counseling, and if there's substance abuse issues, those things need to be attended to.
Your Honor, they have no intention of remaining together, so anything counseling together is not, I would not recommend that. We're okay with any counseling that the court would like her to do. Mr. DeLauder's not here, so I would not want to speak on his behalf.
Okay, well, I think it would be a good idea for both of them and to do it separately. They're not, sounds like they're planning on terminating the marriage in some fashion, but you can't terminate the relationship because you got kids together.
Correct. Yes.
So you got to figure that part out, and for their sake.
Absolutely.
So I would encourage counseling to occur. Did Mr. DeWater give you any dates when he was available?
No, he did not. He just told me that his secretary would follow me either today or first part of the week to get me into the office and get everything started up.
All right, Mr. Stratton, it's up to you then. Do you have a date you want to come back?
At the convenience of the court, Your Honor.
Okay, September 25th.
Who would you like her to go through for counseling, Your Honor?
I'll allow her to pick. I'm not sure how do you pay for medical services, ma'am?
I have a medical card
Okay. And you're living where?
in Azalea, Proctorville.
Okay. All right. Mr. Gwynn said he would talk to you. It's probably the closest facility for you.
What is that, Your Honor?
Oh, yeah, okay. All right.
Okay, next hearing is September 25th, 10 o'clock.
Do I need to follow up with somebody out here about those services too, sir, or anything?
Well,
Or wait till
you want
tomorrow?
to talk to another agency, or Taylor, do you want to talk to him?
Yes.
Okay, Taylor will talk to you.
Thank you, sir.
State of Ohio versus William T. Fields, case number TRC 23763A and B. This is Mr. Holt's case.
This is set for pretrial today.
Not you.
I believe we're going to have to file a suppression motion.
Okay, when can you file that by?
The next couple of weeks is fine, whatever's. I
Well,
haven't
usually
filed before the
what we
26th.
do is come back for a pretrial
Yes.
motion rather than an evidentiary hearing, so I want to make sure it can be filed before the pretrial.
Would we want to have the pretrial on,
September 25th would be a good date for the court.
I have a trial in Sauter County that day. Could we do the next
So we
Monday?
can go into October then.
The 2nd, would that work?
Oh, yeah, that's true. September 29th, we did have a jury trial that's gone out now, so that's a date we could use too, if that's.
I'll be in Common Police Court that day, Your Honor.
Okay, October 2nd then,
Thank you.
for pretrial motion.
And we'll have it filed 7 days before?
Yes.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Gavin Montgomery,
ahead.
Case number TRC 23937. Mr. Stiles.
Your Honor, when we were last here, I requested a continuance to provide Mr. Montgomery with the video in this case for him to look over. He got that from me. Apparently, the files were corrupted in some way. He was unable to view them. I'm going to ask for another brief continuance to allow him to take a look at that, and I've actually made an appointment with him to come to my office so that I can show it and have that taken care of. If we could go to the 25th, I would make that motion, and we would obviously waive time constraints to accomplish that.
What day did you want?
I said the 25th work for you. 25th, we'd said a couple things on that day. My own docket's not too heavy, and it sounded like that was a day that worked for the court.
September 25th for a pre-trial at 10 o'clock.
Thank you. Just put that down. I'll see you then. Thank you.
State of Ohio versus Dylan Hernandez, case number CRB 23381. Dylan Hernandez.
10 o'clock. Your Honor, this was a matter that was to be dismissed if there weren't further problems. This is a 90-day continuance. I don't recall offhand if there were court costs to be paid or not, because this was a situation where it was they were pulled over by the Highway Patrol. The defendant was allegedly in the car with the protected party from a protective order. By the time we were in here, she had gone and gotten the protective order withdrawn as a Scioto County protective order. So I think there was an agreement that it was going to be dismissed in 90 days or if there were no further problems. I'm not certain about costs or if the costs have been paid if they were required.
My note was no appearance required, cost paid, then a dismissal.
Have costs been paid?
No.
And then, fortunately, we just have no cost nor an appearance. So
Now the state want to proceed.
Well, I guess we have to ask for a bench warrant.
Or do you want to continue it? Do you have any contact with this person?
I haven't attempted to contact him because of the nature of the case. Let me make sure. Let me look at what I've got for contact information. If I have just a second here. These are in alphabetical. There we go. They're in alphabetical order. What's the number you've got?
Here.
In that case, then, Your Honor, I would ask for a continuance to a date convenient to the court. And obviously, time constraints would be waived.
September 29th.
Copy that. Thank you, Your Honor.
For pre-trial. Defendant's request.
State of Ohio versus Joseph D. Whaley, case number CRB 23521A and B. CRB 23419, CRB 17133, CRB 17170.
Joseph Whaley had a pre-trial set today, and there's a new charge also he hasn't been arraigned on.
I wasn't aware of the new charge, Your Honor. I think the pre-trial was a matter that had been set for 90-day continuance. However, I think he also had some old charges that were on reviews. I have not spoken to Mr. Whaley very recently. I mean, I've been in a fair amount of contact with him, so I'm kind of surprised he didn't appear today.
All right, so there's no excuse for his non-appearance then?
No, I do have contact information for him, so I'm going to again ask for a continuance to try to round him up.
Mr. Hill.
Well, the new charge, I mean, he had more than one reason to be here. So we would just ask for the warrant to issue, and maybe Mr. Steyer will get to him before the...
Well, the charge is a criminal damaging and menacing from July, and I don't see any form of no service on him, so maybe he probably didn't know about the new charge. So I'll allow it to be continued to September 29th. I'll issue a warrant then if he doesn't show up on. That's 23-419.
Thank you, Your Honor.
And then he had old cases that he had, in fact, pre-trials on review also. in this new charge.
May I approach?
Yes.
State of Ohio versus Landhart, case number CRB 23447 A and B.
Mr. Stiers' case, I'm set for charge.
May I approach, Your Honor?
Yes. Was she referred to QRT or?
She was, Your Honor. She's been non-compliant since she was referred to us. I did meet with her in the office. It took a couple of rescheduled appointments. I finally got her in the office. When she appeared, she was under the influence. I had her assessed with Bethesda, who recommended inpatient. She refused to do so. We gave her the opportunity to do outpatient. She did not show up to sign her treatment plan. She did not show up to continue services after her assessment. And I tried multiple times to get in touch with her at no success.
And Your Honor, she contacted me this week, advised that she had relocated to Oak Hill, Ohio, which I'm not completely familiar with. It is apparently kind of close to Jackson area, and that was the reason she wasn't able to participate in treatment with Bethesda. I'm not aware that we have, I don't know what treatment options exist up there, what there would be at this point. So she is now advising that she would be able to get to Bethesda once a week if that would be the nature of what they would be looking for in an outpatient situation. I don't know if that's what they would be looking for or not.
Doesn't look like it.
She actually met qualifications for residential, but she had a job, she had a job, and so we were trying to work with her. We offered her services for 5 groups of 2 individuals a week with random drug screens. She came in and assessed, did not sign her treatment plan. We've reached out to her multiple times. If it was a problem with transportation, she should have reached back with us. Our recommendation is residential.
I know.
I agree.
Mr. Healy.
Well, that's the opinion of people who are trained to know what somebody needs. We have grave concerns about Ms. Landhart. I don't know what facilities are in Jackson County. I don't know the truth of this, but there was a conversation before the hearing today that there's really not in Jackson County any residential programs.
There's not.
They have kind of a different approach to the way they treat these things in Jackson County. I'm sure that they have problems there, like we have here. So if she doesn't want to do that, then, we would be seeking to just put her in jail. We prefer she go to treatment.
Your Honor, this is a misdemeanor case, so it's not a situation where the case would be nollied to the grand jury or waived to the grand jury. It's misdemeanor possession and some allied charges. She's asked to speak. Before I would allow her to do that, well, I don't have the power to allow someone or not disallow them. Before she does so, I would like to give her my usual admonition that anything she says can be used against her, and therefore generally better not to speak in the courtroom, but as an adult she has the right to make that decision if she wants to make her case to the court for why she shouldn't.
Well, at this point, before she speaks, I think I'm not as concerned that she's going to overdose based on what she's charged with being in possession of that I would be if it was fentanyl. But everything out in the community that you get off the street could be dirty with fentanyl. And she has appeared on an OR bond, so I don't feel like I have grounds to place her in custody. But we'll set it for a trial really quickly, then we'll go from there. So that would be my solution, is to set it for a trial next Friday.
I'm not here next Friday, Your Honor. I'm here the 29th if you want to make it on a Friday.
No, I want it sooner than that.
20, let me look at the calendar. I guess there's like a week between those, isn't there? I'm here the 18th, 22nd, 25th, and 29th.
Let's make it the 18th. We'll set it for trial at noon, September the 18th.
Your Honor, I'm not going to be here that day. If that-
Well, they'll have somebody here, won't they?
Sure. And, you know, the other thing too is that the drugs undoubtedly, I'm going to say undoubtedly, been sent off to be analyzed. We may not have the results back. So that makes a difference too.
Well, this happened July 17th.
They take months to get back. We routinely go 4 or 5 months before drug results come back in common police court.
Is that something you can check on, and we recall this and set it appropriately?
Yes, Your Honor.
All right. This case will be recalled. I won't set it to the 18th yet, so I'll recall it. We'll stay to see what their lab results are if they have any.
Thank you.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Andrew Curry,
No,
case
I'll
number
step
CRA 23464A, B, and C, CRB 23463, CRB 23291, CRB 2361, CRB 22351.
May I approach, Your Honor?
Yes. Andrew Curry is before the court today because he left treatment at Bethesda. Was it last Friday? I think it was last Friday. wasn't it?
Yeah, we got him there and about 30 minutes later he was gone.
So we put it back, he did come in on his own today, and just put it on the docket for a hearing, status hearing. It wasn't actually scheduled for the next hearing until the 18th, but he left treatment without permission of the court against medical advice.
And Your Honor, we discussed this case briefly in chambers with Mr. Keel, and there was a discussion of where he had gone, where he was attempting to go, and whether it was something, whether or not, whether it wasn't a place that we're in court. I guess when he told me about it, he said the name Greenville, which I didn't recognize, which may be RRG, which I didn't realize that was the same.
It's different.
Oh, okay, so it's a different thing. The place he reports that he went was actually Greenville, and I've never heard of that. But he is willing to go into treatment at a location that is, the court approves and that.
Well, I approved Bethesda, he stayed a half hour. Why did he leave?
Go ahead.
4 hours, 4 months for a phone, 4 months for a visit. I'm going to look at the process of RRS, the process is already made so far.
You got kicked out of there.
Yeah, I know, I messed that up too. But I'm willing, I need help, I'm not doing help. And I reached out to others, just not to cut that, I wasn't doing nothing. I cleaned up all my property up, and I have put a court order, since I've been there local, doing stuff to my property. And I reached out to other drug patients. The first day I got out, I was trying to call a lot of patients to go into rehab. And I found the one in Proctorville, the Regal, and they said they reached out to other people, and stuff like that.
Well, before I make any decisions, I want you to do a urine screen. Let's see where we are now.
Our policy is also not visits within 4 months, it's within 15 days.
All right, go do your urine screen. We'll have you back out there and get the results.
Thank you, Your Honor.
State of Ohio versus Edward McCoy, case number CRB 2328, A, B, and C.
All right, Mr. McCoy, sorry we didn't, your folder slipped through the crack this morning. We didn't get, you called earlier.
Yeah.
He's been with RRG.
Yeah, I have a progress report from them, and I'm back in sober living now.
Okay.
I couldn't get a hold of Nick.
Well, he's no longer with RRG.
I know, I
is my
called him till
understanding.
Monday, and I finally got a hold of
So this is
Sam.
Heather.
And he got me back.
Heather can help you. This
Yeah,
is,
she was with me.
Mr. McCoy went to the inpatient program through RRG. Where was it you went?
I went to Glenville.
In Glenville. So, yes.
He's still in the, he's doing everything through the behavioral health thing.
Okay, so you did come back. All right, so you're back with RRG.
Yeah.
And I do have a report, so that's good. So I'll see you in a month. I'll set your next hearing for October 13th.
October 13th.
Oh, you are right. Can you help write that down for him?
I hope you bear swear.
Keep up with your appointments with RRG. We'll see you October 13th.
All right.
State of Ohio versus Amanda Burns, case number CRB 23439.
This is also a review hearing that did not get called this morning. She's a professor.
May I approach your honor?
Yes.
Sir.
Okay. Looks like you're getting some MAT and all your screen is appropriate and the report seems to be in compliance. So how are you feeling?
I'm feeling really good.
Good.
I just want to thank you for giving me a second chance. And me personally, I love Taylor's like groups and everything else, the house, all the girls there and everything. So
Glad you're taking advantage of this and making progress. Looks good. So keep it up. So you've got a good start now. So I'll see you in about a month too. So I'll make it October 13th.
okay, thank
Next
you.
year. And Taylor will let me know if things don't go well before then.
Okay, thank you, your honor.
State of Ohio versus Kyle Akers, case number CRA 23378, PRC 222527, A and B.
Your Honor, Mr. Akers, Mr. Stallard's here, always tracks down people no matter where they're at. Mr. Akers is in Boyd County Jail, not of any fault of his own, because he was revocated over there. I think on this case, maybe some other case, but he's in until February 24 over in Boyd County. So,
Okay. So he's got an OBI here and he's got a warrant out of Meigs County.
Yes, Your Honor. What Mr. Stratton said is correct. I did call the Boyd County Jail this morning to find out his expected release date. The last time we were here, there was no expected release date yet, but they do have an expected release date of February the 20th of 2024, and that should finish his charges in Kentucky, and he will be extradited back to Ohio on our charges at that time.
All right, well, we want to just continue this until after that date?
That would be good, Your Honor.
Yes. So that's going to, February what would you say?
February 20th is his expected release time unless he would do something to foul that up, cause him to have to stay longer. They expect the 20th.
Okay, I'll put it on for another hearing March 1st. He should be here by then. Bond forfeiture hearing. And I'll cancel it if he does show up before then.
Okay.
Thank you.
Thank you, Your Honor. Thanks, Sean.
March, and that's 24, I wrote 23. March 1st, 24.
State of Ohio versus Trevor Dement, case number CRA 23514, CRA 23380, CRB 21167, CRB 2630, CRA 2321, CRB 2322, CRB 19667, CRB 19570. Trevor Dement.
There he is, okay.
Sorry.
Okay, he's got an acceptable urine screen today. See that? I have here a report from PATH.
You got it written down.
Did you look at this one? Maybe we make a line approach with this. Yes. You don't know, it comes in the hands, do you?
Are these for the court to keep or?
Do you need this, but you don't need, no, those can be for the court to keep, Your Honor.
Okay. Well, it looks like he's doing what he needs to do then.
Yes, Your Honor. So our preference, obviously, this is charged felony, but would be to continue to keep it here in hopes that we can continue to track treatment until we get to a place that the state is satisfied. I believe that's what the alleged victims would want as well, from what I was overhearing.
Well, they're here, and so I'd like for them to come forward. James Dement and Cassandra Carter. How are you?
How's the state going to proceed?
Your Honor, we asked for Ms. Carter and Mr. Dement to be here because they are the alleged victims in these matters. We wanted to make sure, given the ongoing issues that we've had with Mr. Dement and the seriousness of the charges and whatnot, we wanted to make sure we had their input as far as what course we're on right now, which is the treatment course. And I believe that each of them is agreeable to that. Not, I mean, it's going to have to stick. It's going to have to be positive from here forward in order for us to continue to keep the cases here. So if he wants to continue with treatment, then we're going to ask for a time waiver and to continue good reports and no further problems with either of these people. That's what he's going to have to do to keep it from going to the grand jury.
Your Honor, that was our plan, so we are on board.
Okay, so there is a time waiver. We'll come back. Let's make it October 6th.
Make certain I'm available that day, but I don't think there's a reason I wouldn't be. In fact, I'm already on the docket.
October 6th will be the next hearing.
No.
On all the cases, Mr. Dement, you're capable of doing this. And you've got a lot of reasons to to make it work. So, do so.
And there's still protection orders in place, and we're serious about that too,
Okay.
just for Mr. Dement.
All right, the protection order remains in effect from them. October the 6th is the next hearing. Keep up with your counseling like you have.
Thank you, Your Honor.
Get good reports and good screens.
Thank you, Your Honor.
Thank you for being here.
State of Ohio versus Christopher R. Hale, case number CRA 23424, CRB 2487, CRB 1964.
Mr. Steyer's case, preliminary hearing.
Looks like we're getting some good progress here. Well, let me ask, is this something you would support? Yeah. Okay, if you'll support it, we can get it done. Yeah, okay.
Okay. Sounds like he's making progress, but still has things he's working on.
Correct, Your Honor. And as part of that, he's reached a phase in the programming where he would qualify for passes, but as of right now, he has an ankle monitor on, which would prevent his being able to take those passes. I just asked Mr. Gwynn, he said he would be supportive of the idea of removing the ankle monitor at this point. I think we're time where you're going to have, and Mr. Hale's going to have to understand this is going to be a chance to prove himself, but it also could be a chance to sink himself. So he's got to choose which of those is going to be. But I think part of the programming is getting to that point and getting out there and trying.
Mr. Healy?
Was he already on GPS for some other reason?
I don't think so.
One of my notes seem to indicate that, but,
Who has you on the GPS?
Mr. Crabbe.
Okay.
I think that was because of perhaps not appearing in the past on some other.
Yes, but it is out of this court.
Yes.
So if the agency that he's doing his counseling with feels that it's appropriate, then we don't object to it, and if there's no other reason that the court has that he should stay on that, we're not in opposition.
Are you going to stay in treatment even without an ankle monitor?
Yes, I will. I first off want to say thank you, but apologize as well for the disrespect of, I took it as a way to get out of jail before, just to be honest with you, and you let me out, and I just wasn't taking it very seriously. But now since I took it seriously, I'm starting to, my mind's working really well, and they got me on some medication, and it's helping. I was a little drowsy at first from taking it, and kind of dozed off a little bit, but I've gotten past that. But I'm starting to care about, tomorrow, like other people's tomorrows as well, because I understand this isn't just about myself. I got a son, and he's got football games and stuff, and, they're right up the road at a church, and, and I talked to my, Miss Becca there, and, she said that as long as I can get past this drowsy part, and I thought, it's really not a whole lot to ask. If I'm going to put the hard work in this to move to the next phase, and, so it's not a hard work at all, really. I mean, it's just about making my life better, and that's what I want to do, because, my home life, I have a good structured home life that is willing to help me as long as I'm clean and as long as I'm working. And that's, that's just, something very simple. I'm an adult now, so that's what I'm going to stick with, and I'm pretty interested in the classes there of helping getting a job like what these good people do. So I would like to, let you know that as well. I'm going to take a course in that.
Okay. I like what I'm hearing. Tom's going to tell.
Yes, sir.
It appears, and I made this comment last night at a meeting. At first, people go into treatment, and I'm okay with them going to treatment because I make them go.
Yeah.
Because something just like what you said, some people's brain is in a fog, and you need that fog lifted before you can start making decisions on your own. But at some point, this has to become your project, not just mine. If you're only doing it for me, I can only stay on you so long, and then you're gonna fail because you're not doing it for yourself. But this is for you, for your son, for other members of your family, for the whole community, really. You're gonna help all of us if you get clean.
Yeah, and I want to
What
be,
you can do, what the clean Christopher can do is positive. What the dirty Christopher can do is a drag on all the rest of us. So you getting clean not only helps you and your son, helps you the most, the people that are most close to you, but it helps the whole community. So I applaud what you're doing. I want you to see you be successful, and I'm going to take the chance that you're not going to quit because I'm taking the ankle monitor off. So
I won't quit.
Order it taken off.
all right, I won't quit, I promise.
And then we'll see you again. Let's make it October 6th. I know you're already here that day.
I am, Your Honor.
So all of his cases are set for October 6th. We'd like to see Mr. Cooper about getting the monitor taken off.
All right. Thank you, Your Honor.
Thank you.
Thank you, Your Honor. State of Ohio versus Devin Stapleton, case number CRA 23494A and B, CRA 23491. Devin Stapleton.
All right, this is a case that we discussed in chambers.
It is, Your Honor, and Mr. Stapleton, you advised he wasn't required to appear today. Some of his treatment folks are here though. I guess I'm gonna say on his behalf, but to make sure that we know, that he'll be able to know when to get back here and any updates that are necessary.
May we approach, Your Honor?
Yes.
I appreciate your input. Now, ladies. Thank you.
the state's made a motion for the court to make an order finding that Mr. Stapleton should be housed at the Galapagos Developmental Center. So, and I understand Mr. Steyer is objecting to that, the state is objecting to that.
Yes, Your Honor, I'm objecting to that, to the state's motion. It's my understanding that because we have a suggestion of competency pending and the evaluation has not been completed, that the case has stayed. So I don't believe that that's properly timed.
All right, I'm going to overrule your objection. I'll enter the order as it's presented to me. I'm going to set this for another hearing September 22nd. We'll, as a preliminary hearing and pretrial, and we'll look then at the competency issues. There should be more information back from Court Clinic by then as to what they're willing to do and what they won't do. So I'll enter your order as presented, Mr. Hill, and September 22nd will be the next hearing date.
Thank you.
10 o'clock.
State of Ohio recalls Andrew Curry, case number CRA 23464 A, B, and C, CRB 23463, CRB 23291, CRB 2361, CRB 22351.
You seen the results?
I have.
Your Honor, I just looked at this screen when I went back there again, and on the morphine, there is a line starting to pop up. So he would, if I seen him first, I would have said it was me.
But you stand by the cocaine and
Yes, yes. He asked me to double check it again, and I did, and it is starting to pop up. It's a very, very faint one.
Well, I still think he needs inpatient treatment. I made the order for him to go to Bethesda. I'm willing for him to go back there with an ankle monitor now.
We would be willing to take him.
So I had 4 months for a phone and 4 months for a visit.
If you'd have stayed long enough, you'd have heard that. 15 days until visit, and then you start to get phone calls after 15
I
days.
had 20 days.
Well, she's telling you 15.
What was the difference?
What new place? Well, this is where you want for you to go, so are you going to go where you want for you to go?
Yeah.
Okay.
Okay, I'm ordering him released to Bethesda with an ankle monitor in place to be placed by adult probation. And hopefully
We're
that'll
currently
happen.
on for the 18th. I don't know if that's an appropriate day to keep.
I think it is.
Good timing.
We'll keep it then. I'll see you on September the 18th. Now, I feel like I know you enough, but I need to really caution you because this is serious business. Once I place an ankle monitor on you, you know this?
I know.
If you cut it off, it's it's not as bad as you think, but it's still bad. 3 years in prison. It's 3 years of nothing I can do about it. You're going to go to prison for 3 years for cutting your ankle monitor off because you're going to go to the common pleas, and that's the position that both judges are taking. If you cut an ankle monitor off, you're going to prison for 3 years. So, do not cut off your ankle monitor unless you want to go to prison for 3 years. I've told people that, and they still do it. It's not worth it. No matter how, a few days that you get out free, it's not worth it. Okay? Okay, I'm remaining you into custody until the ankle monitor is placed. So he can stay here, or it'll probably have to be transported. However, we're going to work that out.
I will call off probation.
And they normally text me and let me know when they're ready, so.
All right. Next hearing is September the 18th.
What's your question?
I have a question on that. Is that going to affect me getting my license?
Yes, it is.
Non-conforming?
It is.
To my fiance?
Yeah, it's going to affect the passes.
It'll affect until you demonstrate to me that you're going to be serious about this. And you left in 30 minutes. I sent you there a week ago, and you left in 30 minutes.
Say it's not for a while, get a little time on your belt, so they cut off, and you have to return back.
Thank you. Thank you.
State of Ohio versus Kenneth E. Cogan, case number CRB 23420.
All right, Mr. Cogan
Yes, sir.
is here today, and you'd entered a plea, and I continued it for a while to see if this could be resolved. This is over some taxes. Did that get resolved, or what's going on?
Tax masters is still working on stuff. Debbie left us in a good mess.
Okay, so it hasn't been, do you have any information on this, Mr. Field?
I do, Your Honor, and I've spoken with the agent from the Ohio Department of Taxation, and the main thing that they need for Mr. Cogan to do right now is get current with his sales tax right now, going forward.
That's what tax masters is working on.
Okay, now, he has an arrearage from several time periods in the past in which they were not paid, or that not enough was paid or something. And there is an estimate that is made by the state of Ohio if there's not a return that's filed in a timely manner. So the amount that they say he owes now might be exaggerated. It might be more than what it actually is, but he's going to be responsible for turning that information in and make sure it's accurate. They are not interested through this case at this point in time in trying to coerce money out of him for arrearages. What they want to do, and I suggested to the agent that the way that we would like to handle it is to come back and check his progress again, make sure that he's paying regularly and doing something towards the arrearage before we would ask the court to pronounce a sentence.
Okay. When do you think that can happen, Mr. Cogan? Are you paying as you go along now? You need
I don't know nothing about it. Tax masters is the one taking care of it.
Okay, well, is that something in their bailiwick that they do?
Yeah.
Because I don't know. Maybe, have you ever had an accountant? Maybe you needed a personal accountant.
Have I had one now?
An accountant, a CPA.
Yeah.
Certified public accountant. Have you had one? Who was that?
Debbie Broughton.
Is that the person you think that messed this up, or?
That is.
Well, you probably need a different one then.
Yeah, but that's what, we got tax masters working on it right now.
Okay, I'm not downing them, but I just don't know if this is the type of thing that they do on a regular basis, but that's up to you. So, we had continued this for previously, what, 6 or 7 weeks. Do you have a time frame in mind, Mr. Hill?
Well, let's see, July 28th, I guess, is when he was here the last time.
Right.
Maybe 60 days, something like that.
All right. I'll set the next hearing for November the 10th, Mr. Cogan.
November the 10th.
So try to get it straightened out and start figuring it out before then. Give me a good report when you come back.
They're working on it.
All right, November 10th, 10 o'clock is your next hearing. That's all. You're pretty good.
State of Ohio versus Garrett Johnson, case number PRC 23386, A and B.
Good afternoon, Your Honor.
Good afternoon. This is on sentencing and for Mr. Johnson.
That's correct.
Do you have a report of his activity?
I do, Your Honor. May I approach?
Yeah.
Thank you.
this is dated September 5th. It doesn't really say, doesn't really say how many sessions he's been to. I have some prior notes of sessions.
Right, Your Honor. He has been consistently attending every other week since that time, and since early May.
Okay. Have you seen this, Mr. Hubert?
I have, Your Honor. I'm rereading it right now. When I read it before, it seemed to be first of all, a little bit more complete than the last time, and I know we had discussed the fact that the last time was a little vague, maybe one sentence.
Yes.
And so this is a little bit better. It appears as if he is taking part and staying in compliance with their program, so we wanted to continue to do that. Right now, I think that it would be fairly characterized that Mr. Johnson is trying to convince the state of Ohio that we should recommend something less than jail time. This is a first offense high score, so he's got some work to do still, but we feel like he's made some progress.
All right. Mr. Donald.
Thank you, Your Honor. Yeah, so this is an incident stemming from April 8th. Obviously, one of the things that's not in there, Your Honor, is that my client got an assessment there at Huntington. I think it's end of April, too. So obviously, after the assessment got scheduled. So he's been consistently engaged in counseling now for a little over 4 months. He's a student at Marshall. It's a one-time incident. He does take the incident seriously. He takes this process very seriously. Not looking to get out of anything. Obviously, he's acknowledging what he did was wrong. I just think that he's going to continue to engage in counseling. But he's graduating from Marshall here in May coming up, and he wants to go into the healthcare industry, either pharmacy, somewhere in that area. So I just think that he's going to continue to demonstrate to the court whatever he needs to do. But
well, and you understand that under Ohio law, there's a mandatory 3-day jail sentence if you test above 17, and he's tested 19 something. So
correct.
You're asking for a deviation from that. So that's extraordinary. I mean, that's not what we usually do here.
Understood.
So the state's not willing to agree to do it yet. You're saying he should continue with his counseling. If he doesn't want to do that, I'll go ahead and sentence him to the 3 days in jail right now.
He's going to continue to engage in counseling regardless, Your Honor. So I'm sure, without even speaking to him, he'd much rather continue to engage in counseling.
Well, I think he would too if he's seen the inside of Lawrence County Jail. It's a place to be avoided. So,
based upon my interactions with Mr. Johnson, Your Honor, I don't know if you'd fit in.
The father didn't seem to be too happy about it, sir. Do you want to come up and address the court? No. You understand your son, the legislature in Ohio has said anybody that tests above 17, I am required to sentence him to at least 3 days in jail. Do you understand that, sir?
Yes, sir.
And your son and his lawyer are asking me to deviate from that standard, which I rarely, if ever, do. Do you want to express your displeasure with my ruling?
No,
to
sir.
me personally?
No, sir.
You think I can't see you sitting there in your actions?
It wasn't directed toward you. It was when you said what the inside of the Lawrence County jail looked
No, I don't think so. I wasn't born yesterday. Your son is how old now?
22.
You're welcome to be here, but you're not welcome to act out.
I apologize, Your Honor.
Thank you.
Sorry about that, Judge.
Your son is a full-grown man. If you want to come, you're welcome to, as anybody is welcome to come for a public proceeding. But your presence today hasn't been very helpful to him, has it? What I need to be convinced of is that this is never going to happen again before I would ever go here. Okay, we're going to come back in about a month. What's your schedule?
Sounds good. Your Honor, in light of the report, would it be possible to do it online by video, or would you prefer?
I want him here in person. And you can come at noon. You don't have to come. We're never finished before noon.
Understood, Your Honor. Let's see here. A little bit of a limited signal, I apologize. I'm trying to use my phone to pull up my calendar. Your Honor, would it be possible to have my office call? I apologize to the court right now. I'm trying to.
Well, I'm just going to set, the way we work, I'm going to set a date. If that doesn't work, then you can file a motion for continuance.
You got it.
October 13 for sentencing at noon. Continue with your counseling, get me another report.
Thank you, Judge.
You're welcome.
State of Ohio versus Joshua M. Hay, case number CRB 21324. Joshua Hay.
This is Mr. Morford's case, after sentencing. This is on sentencing. He has a case pending in common pleas, which I understand is going to trial.
Yes, Your Honor.
That's the end of this month sometime.
Yes, the 29th.
So the reason it was set for sentencing here, I think he has a bond up on this matter, and it was had been a review hearing, he missed, and then he posted bond, so it's been set as a sentencing. It was a theft conviction. He has, yes, he has a bond up now on a failure to appear for a review hearing. He has a fine, and court costs, I believe, is all that's here, but he's, I assume, not working. You're on some kind of judicial release on the
I'm on house arrest.
Home arrest. So we've just been setting these hearings to monitor what's going on with common pleas. So
Hopefully
nothing's going to happen until after the trial, one way or the other, right?
Yes, Your Honor.
So let's come back in October. What is the actual trial date?
The 29th.
29th of September?
Yes, yes.
Okay, how about the 16th of October? It'll be completed by then. We'll know the status.
I'm here then, that's good.
October 16th?
Yes,
for
Judge.
sentencing at 10 o'clock.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Brian K. Stapleton, case number TRD 28983 A and B, CRB 22573.
Excuse me.
I think you have insurance. It says on the ticket you have insurance.
got the issue of restitution to Buckeye Rule, and then we've got
Well, it's just,
driving here just without a license, looks like.
yes, Judge.
And any news on the restitution front?
Yeah, I got $100 to pay on it today.
Can we take $100 on restitution and hold it?
You already used, it was set on 22,573, he's already been
Yes.
sentenced on that, so there's no issue with it.
All right, thank you.
Oh, yeah, I done that.
Okay.
Yeah.
All right, and then on the 23,983, how do you want to proceed on this?
Which charge is that, Judge? The
That's
driving?
the no operator's license
He's going to have to change his plea, Judge, to guilty.
and failure to yield. And there was a crash here too.
Your Honor, the
Did you have the license?
other driver, the non-at-fault individual, we have made attempts to contact that individual and have been unsuccessful at the telephone number and address that we were given. We noted on the ticket that I think it says that he had proof of insurance. However,
Yes.
it may be that he actually didn't. I don't know. That we thought, well, he had insurance, that's the best we can do, but I don't know if he did or not.
Well, the insurance was on my
It was
wife.
on my truck, he didn't have insurance
Yeah.
from my insurance company, he didn't have one.
Did they specifically exclude him from the vehicle?
My husband, yes.
The insurance
Yeah, but
company
the other
said,
driver didn't have insurance, even though he had proof of it.
your insurance company said, we will not cover him if he's driving the vehicle, correct? Before the wreck.
No, they didn't say that before.
Well, they have, see, you
Because I
have
got-
coverage for anybody that drives your vehicle with your consent unless they're specifically excluded. So the insurance company can't say after the fact, oh, we're not paying because Brian was driving, unless they said that before the fact. Now, if they said before they insured you, we're not covering him, and they can specifically exclude somebody.
Yes, they did, and I just restarted the insurance again and everything with them. They did
Okay.
both times, yes.
So they had, before this wreck happened, July 20th, they'd already told you, we will not cover him if he's driving your vehicle.
Correct, and the other driver didn't have insurance. It was elapsed.
Okay.
Your Honor, there's an additional note here on August the 14th. The Jonathan Reaper, the other party, actually contacted our office and left a voicemail asking why on earth we were trying to contact him, how did we get his information, and how did we know about the accident, and it appeared as if he didn't want to have anything more to do with us, so.
Okay. Well, if he's not going to come forward and testify, and he's had plenty of time now, and obviously he knows he was contacted, then I think we can go forward without ordering restitution. He still has a civil remedy if he wants to file suit against you and get a judgment that way. So I'll go ahead and accept the guilty plea on the no operators and failure to yield at a stop, at a failure to yield sign, or a yield sign is what it was. Anything you want to say, Mr. Stapleton?
No, not really. I mean, I shouldn't have been driving. That was my fault. I was doing something for my kid and, got into an accident.
Okay, on the no operators, I'll impose a $150 fine. And then on the failure to yield, a $50 fine. And he's already been sentenced on 22,573, and he's going to pay $100 on the restitution today.
Yes,
For
sir.
that. So I'll set both for review hearings. October 27th for review on both.
At 9 o'clock review,
9
Judge.
a.m., yes, sir.
No, it's not. I keep paying.
Okay, see the clerk, sir, make your payment, your any payment you make first will go toward the restitution.
You can pay it online.
But do I have to show this court?
State of Ohio versus Lance M. Davis, case number CRB 2350 A and B, PRC 2339 A, B, C, and D.
May I ask you a question on
Yes,
this,
sir.
Mr. Faithful Judge? He's wanting to know if he's got everything paid off, if he would have to appear on October 27th.
He will not.
Okay,
After you pay everything off, you can quit coming to your review hearing.
okay, thank you.
Thank you, Judge.
Lance Davis.
May I approach, Your Honor?
Yes. Okay. Well, he hasn't appeared for assessment.
He's not here today.
And this is, oh, guess I don't think I'd sentenced him yet.
No, this is a sentencing today, or supposed to be.
So rather than sentence him in absentia, I'll just issue a warrant for him for not appearing.
Thank you, Your
I
Honor.
appreciate that, Your Honor. I don't see the jail up there.
We'll get enough as soon as we're ready.
Oh, okay, okay.
Okay, and on Lance Davis, I would like for his holder to be without bond. So I don't want him to be able to post a $1,500 bond to get out. So if we can make that no bond on Lance Davis, since he's for his holder for warrant.
You just issue insurance on to do what?
No bond. I don't want him to be able to post bond.
You write that down, so I don't want that.
Okay.
State of Ohio versus Clyde King, case number TRD 20-2187 A, B, C, D, and E, CRB 2825, Clyde King. Not checking in, Your Honor.
Yeah, but I looked earlier, he hadn't checked in yet.
And he hasn't completed everything. I told him the last time he could work everything off if he wanted to, but I don't think he's done anything. So it'll be eventually. Failure to hear.
How much did he have left? Was it the point where it was possibly would have worked it off? Because it might.
It's over $400.
Okay, probably not then. I'll go ahead and check with Mr. Cooper, and if it turns out he's had it and does not entered it, I'll get it recalled. Otherwise, we'll, whatever.
State of Ohio recalls Tanya Lanhart, case number CRB 23447 A and B, TRD 23963 A, B, and C.
Your Honor, can we approach?
Yes.
It's been entered in the system, but nothing yet. I mean, they don't look like it's going to have Facebook.
This is 23447 and 23963 is a TRD case.
I got people now, I'll drive down here myself. I can't live down here anymore. For my sake.
If we send her back to you, can you get that up here someplace that she's gonna have? It's practically there. Let's try that. If we send her for she'll walk. Okay, so I'm canceling the trial September the 18th. I will set another pretrial 29th. I'm referring you back to QRT. I'm going to let you try outpatient again. And Megan's going to try to get you someplace in Jackson, close to where you are living now. But you got to make it work this time. No exceptions.
Did I hear the 29th, Your Honor?
29th, are you available then?
I am. I just want to make sure I put it on the right date on my calendar.
Okay, talk with Megan. She was going to assist you in getting with an agency in Jackson.
Have to be.
And Tanya, I just want to,
It's not dismissed to QRT.
It's not.
No.
We'll come back on the 29th for a pretrial.
Tanya, I just wanted on the record, you have to respond to me when I call with
My
this.
phone is still in my vehicle in the impound lot.
Okay.
The phone I have today is my.
Can I reach you on the number that you just texted me from a few days ago?
Yeah.
Okay.
You're going to keep that number? You're not going to change it?
I'm going to the impound lot when I leave here to get my phone out of there. I had to meet Cold Grove Police Department down there to get it. So I'll have that number back.
They're going to give her her property out of the car.
Yeah.
Okay.
Thank you.
Thank you, Your Honor.
Okay.
State of Ohio recalls Devin Stapleton, case number CRV 23494A and B, CRA 23491.
I don't, they were sitting out. Yeah, I heard there was an issue.
Approach your honors.
Yes.
State of Ohio versus Sean Deweese, case number CRB 22-637A and B.
Morford's case, set for pretrial. Canceled the warrant. Mr. Deweese showed up late.
Yeah, I will apologize for that, Your Honor. I worked over a little long.
Do you have a report from Pathways?
No, sir. When I went up there on the 30th, see her, I told her what y'all was needing, another progress report on me, and she told me to try to get Mr. Phone number for him. She would call him and ask him to see what's he needing from her, is what she told me. I got the phone number and give it to her, and she's supposed to get in touch with him.
And she or somebody from Pathways actually reached out at the prosecutor's office yesterday, but I wasn't able to make that connection. So at least they've tried.
So you're still there, still getting?
I call and make appointments when you ask me to, yeah. Yes, sir. But she's, the last full class that I was in there with her was when you got that last full report on me. The good report, not the one with just the times on it.
Are you going on a regular basis?
I'm just doing it, yeah, just whenever, if he asks me to go, I call him and make an appointment. But no,
When
there's
the
no.
judge has to go, but
No.
does your plan require you to?
No, no.
Well, back in January, my notes were this was going to be dismissed with counseling after 90 days. I don't know if the state's satisfied or how you want to proceed.
I wish we,
Sorry.
I wish we had a report from Pathways. I know that the individual called, oh, here we go. Is this, no, that's not.
And I think my fiance talked to Miss Jasmine yesterday too.
I thought he was going, does he not have the report?
No, remember somebody from Pathways called the prosecutor's office yesterday for me, but I never.
She must have not gave it them to her. It said there's completion. Does he not?
Report letter of completion.
Was it back? The court don't have it either?
No.
Because I don't.
How does the victims
They're fine. They're fine. They want dismissed once completed.
Okay.
And apparently it is because I called Missy and told her.
Who called Missy and told her? You mean Pathways? Or do you mean the victims?
I spoke to them, but then Pathways.
But they're
called
satisfied
Missy.
with everything at this
Yeah,
point.
that's what Missy told
All
us,
right.
that the lady called them.
The victims are satisfied with his progress. So that's, that much anyway. I know that Pathways has attempted to contact and speak to me directly, which is a little bit, it's not the way it normally happens, but we're satisfied at this point that if he pays, I'm looking to make sure that we ask for court costs, yes, that we would be willing to offer a dismissal if he paid the court costs.
Absolutely.
Under two, can you pay that today?
Friday.
Next Friday?
Yeah, that's Friday.
He's going to need 1 week, Your Honor, to come up with court
Here's what I'll
costs.
do. I'm going to continue it to October the 6th. He pays the costs. By then, he doesn't have to appear. He hasn't paid, he has to appear.
Thank you.
So you can pay it any time before October the 6th.
Could I ask you what the price was on it? What's the payment?
I'm sorry?
What was the payment of the court cost?
Court costs,
Just 110? Okay.
110.
which would be $135.
135 with the fee.
Signed counsel fee,
Right,
too.
thank you.
$135.
Your Honor, looks like there's also a $20 fee on the services something.
Okay, there was a sheriff fee of 20, so it's going to be $155.
It's fine. Thank you.
You're welcome.
Good, buddy. Yes, sir.
Okay, we're going back to the jail to finish up some cases there.
State of Ohio versus Joseph Atkins at the Lawrence County Jail recall, CRA 23260, CRB 23261, PRD 182412.
There is Mr. Atkins, and this is Mr. Smith's case. Okay, was there an assessment done?
Yeah.
What's your recommendation?
He doesn't have insurance right now, but we'll take care of that, get him together, and send him to Glenville, if that's okay with you guys.
Yes. Mr. Atkins, what say you?
That's all.
And how will we make the transportation happen?
I'll have to get a mail coach over to get him
Okay.
whenever he's released. Do you know around about what time it is? Will
As soon as
be?
we send the paperwork down and
Okay.
somebody shows, well, I'll just order that he be released only to our RG representative, so whenever, should be this afternoon,
Okay,
if you can get somebody there then.
yeah.
Order to inpatient treatment with RRG.
He says, fine. So, do you want to tell him to just get a copy of the clerk's office here in a little bit? The judge signs it.
Yes.
Just the amount of the signature line.
Signature bond of $2,000. And set, just to make sure he's there and doing what he's supposed to. When are you back in the next couple of weeks?
Well, it's
Or
Roger. He said that any of the next 3 Fridays, he's available.
Let's set it for September 22nd. So that's 2 weeks from today. And that'll just be a status conference to make sure he's there and doing what he's supposed to. Okay, you'll get picked up today and go to inpatient treatment. I'll see you. What has happened in the past, I think they've been by teleconference.
I believe so, with being in Glenville, it's done through Blue Jeans in the past, so.
Yeah. Okay, good luck to you, Mr. Atkins, take advantage of this. If you don't do it, then we're gonna send your case on to the grand jury, you'll get indicted and go to common pleas, felony court, and risk going to prison. So this is,
I want to do it, thank you.
this is a good deal, you get treatment and take prison off the table.
Thank you, sir.
You're welcome.
State of Ohio versus Robert C. Level, case number CRB 22672. Christy Jordan is on deck.
Robert Lovell is Mr. Stratton's case.
Yes, Your Honor. We recalled it so that the state could attempt to contact the victim in the case.
And the answer to that is here we go. We don't have a current telephone number for her. So our intention is that this would be a 90-day, let's see. What did we, how did we, oh, did he plead guilty? Yeah, he pled guilty, okay. That we're going to be recommending a suspended jail sentence unless we find out, unless we're able to get a hold of the victim and find out that there've been more problems. That would change our minds about this. And we're going to make every effort to get a hold of her, although the telephone number we have for her is no longer working.
So, Your Honor, that just has to be set for a sentencing date. There's a protection order in place, so.
All right, so he has entered a guilty plea. I'm going to let him out on a $2,000 OR bond and order him back for a sentencing on September 29th. So you need to be in the court at Chesapeake September 29th at 10 o'clock, Mr. Lowe. I'll let you out of jail today.
Cross the hearts where I will be here.
Okay. See you then.
Thank you, sir.
You're welcome.
Bless your heart. State of Ohio versus Christy L. Jordan, case number CRA 23549, CRB 23551. And John Crowe is on deck.
This is Mr. Steyer's case.
Yes. We may have the camera aimed incorrectly, but it looks like that may be her
See the
sitting
top of
there.
her head. And you just pull the
Hold
lens.
on 1 minute. Wheeler, they can't see me.
It just needs to be adjusted. You need to back up or move the camera down a little bit. There we go.
Okay.
That's good. Thank you.
So, Your Honor, we have a couple different issues that are causing us complications. One is she has Medicare, not Medicaid. And that difference means basically that I'm not aware of anyone that will...
OBP?
No.
We don't accept Kentucky Medicare.
Oh.
Well,
I thought she was from Michigan.
She lives in Louisa, Kentucky, has Medicare in Kentucky.
Yeah.
So OVP...
ARC can't do...
ARC can, but ARC wants her to go through a detox before they'll take her, and I got some other medical issues that are giving ARC cold feet, unrelated to the treatment matters. There's just some other medical issues that are a problem.
and Ironton Municipal Court had anticipated that she would be going to ARC on their charges.
So as of right now, I have no idea what we can do.
Someone that works in our network mentioned the hospital in Louisville. I can try to look into that.
I know that in Florence, Kentucky, they have a med open too. They said they'll take me.
Well, who in Florence, Kentucky?
It's a rehab. My sister went to home and she got in trouble.
Do you know the name?
It's called Florence, Kentucky Rehab. That's what I thought.
Creative name.
Okay.
And they said they'll take me with my insurance and everything. 'Cause I have Medicaid and Medicare. I have both. I don't know what the confusion is, but I'm on disability, I'm full disabled. I have.
Well, if you receive SSDI, not SSI, or even both, if you receive SSDI, I believe you primarily have Medicare, and you may have Medicaid as a supplement, but I think that in that situation, Medicare has to be billed first, and that's what causes the problems we're having. So the upshot of all this, Your Honor, is that I don't know what we can do with her today, and I'm not here for the next 2 court dates. So I don't know that I'm going to be the best choice to deal with this issue.
Who represented her in Ironton?
Gene has her in Ironton Meadows.
Yeah, I gotta appoint him.
I don't know if he's available. I don't know. I mean, if something would be looked at over the weekend, I don't know if he'd be available Monday, though, is the issue.
I don't have his contact, I don't think.
I do, Your Honor. I can forward it to you. yeah, he sent me information that it was gonna be ARC, but this stuff sounds like what we're being told here, that she's not gonna be. Now, here's the other thing too. They've spelled her first name differently in Ironton, and I don't know how.
The way she says it's spelled here, the way she says it's spelled is how it's spelled here.
Kristine.
Okay, I sent Mr. Meadows a text asking if he could explain, trying to explain briefly what's going on here and asking if he can represent her in this court, so we'll see if we get a response.
Well, let me ask you this. Ma'am, do you have court again in Ironton Municipal Court, or has your case already gone on?
They thought I was going to treatment, so they made my next court date kind of way out there. It's next month on.
You have a scheduled date in Ironton Municipal Court?
Yes, I do.
Okay.
I'm looking on here, but I can't, they must
How
have
did-
the name spelled, here we go.
Okay.
What state it is.
I don't know if this is helpful, but John told me that he didn't think she had a court date.
I'm sorry.
John told me that there was no follow-up court date, because it was being bound over to the common police.
Yeah, her case is going to the common pleas court.
And so it's already been bound over?
Yeah, so it's probably going to be best for us to do the same thing here, whether we can do it, whether she'll agree to waive or not, I don't know. She's got a,
Well, no bond's been set that I'm aware of, so there'd be no reason
That's
for it to
not-
waive.
We haven't got, we were looking at
Right.
treatment, but
Yeah.
you can kick it to the common pleas and let them figure it out.
That's a possibility, obviously, but that'd be the state's motion.
well, we were in Ironton under the belief that she would be going into treatment. And now I'm recalling the
That's
circumstance.
that's why I waived my preliminary, was so I could get it for treatment. Without that, I wouldn't have waived it.
Right. So now she can't get into treatment. She was given an OR bond in Ironton, knowing that she...
Conditioned upon the getting into treatment or not?
Yes.
Okay.
Yes. So,
You can nolly here. It's
Either way, I'm going to treatment, no matter what. With or without, you guys may keep me, I have to go. I have a daughter, I just got her back, and I can't risk losing her again.
The problem is finding a place that will take you.
Right.
Well, my family, they set up like I said in Florence, they said they got a bed open, they take Medicare, they take methadone-assisted treatment people that are, because I told my dad, you got it. My dad's been on it for 10 years, and my whole family has. It's helped us. So they just got to get me into a facility that will accept someone that is coming off of it. I've been off of it for almost 3 weeks, I'm not even DTing anymore. I don't understand why ARC wants me to go through treatment when I already detoxed from jail. I'm not even withdrawing at all.
was that the only
I
thing
don't
keeping
know
her?
why she told me on her pre-screen yesterday, then that she had last used methadone on September 5th.
The last time I used methadone I called my treatment center, Ultimate Treatment Center in Ashland, Kentucky, but it's been about 3 weeks. At least.
Is it that issue that's keeping her from ARC?
That was my understanding, was the issue, that,
It's not just,
not just that issue, but that's primary.
I may have gave him the wrong date. I don't know, I came in on the 2nd, but I haven't used methadone for at least a week and a half, 2 weeks before that.
I think the place she's referring to is Gateway Rehabilitation Hospital. It's in Florence, Kentucky, and they accept Medicare and Medicaid.
if she were to get there herself, how would she get there?
My father, he already said he would take me straight there, my dad don't even want me home right now, he wants me in treatment.
Where is he?
He's in Louisa, Kentucky. His name's Christopher Jordan.
So that's where you've been living?
That's where I've been residing the last year, yes, sir. My stepmom's a doctor at Three Rivers in Lawrence County, Louisa. They don't put up with none of this stuff either, so.
If I'd feel a whole lot better about it if we had him here to say, I'll take her today. And
You can call him on the phone right now.
You have a phone number for him?
606-369-3659. His name's Christopher Jordan.
606-369-3659.
3659.
Brand, yes.
Correct.
I just called a program called Edgewater in Kentucky, and they said that they can accept her with Medicare because
Might have to leave a message to
grant
answer
funding
tomorrow.
for it.
Hang on a second, ma'am.
They have grant funding for it, and they also treat co-occurring disorders.
And where are they?
Hold on. I had called Pathways. It's in Moorhead, Kentucky.
That's not too far.
It's better than Florence as far as distance.
Is there a way to get her there?
Her dad.
If I can call and leave a message and he calls me back. I can.
G Meadow says he will represent her if I want.
It's your call, Your Honor. I just feel like this is something that maybe is going to be more complicated. It's going to be dealt with today and back when I'm here again. But if we can get her somewhere, it's a moot point. Because then I'm not worried about getting her back in here Monday or Friday. So if you want me to step out and try to call her dad and see if I can arrange transportation.
Then can we get the order from our municipal modified, because it was ordered her to be released to ARC?
Well, I've sent a message to John Kincaid, and I have not gotten an answer back yet.
Okay.
So I'll step out and try to call her father.
Okay.
And what was his first name again? Okay, thank you.
We'll have you back after your lawyer
This case.
talks to your dad.
It's set for
State of Ohio versus John Cronin, case number CRB 23244 A and B, CRC 23431 A, B, C, D, and E.
Oh, yes. Yes, if you can find the file.
This is Mr. Warford's case. You were going to talk to Mr. Cronin about what the results of the urine screen were and how he wanted to proceed.
I've discussed that with him, Judge, and he wants to go to treatment.
Okay.
Obviously, he has a dire need for it based upon those results, and I believe he realizes that.
Okay, does he, there are no felonies here, is he going to enter pleas to these misdemeanors first, or how do you want to?
I'd like to get him into treatment for a little bit, Judge. I'm not sure if he's detox, I'm not sure of his decision-making ability right now.
He's been in jail for a week.
Yeah, he's going to have an ankle monitor. I don't know if there's one available, but you know about ankle monitors, because this gentleman probably needs one too.
It'll probably be Monday, Your Honor.
I'd like to make a recommendation as to what we would want if he were to plead guilty. First of all, this is a first offense OVI. We know what the results are, so we have concern about him getting treatment. We'd want him to go to treatment. The other charge is an unauthorized use of a vehicle, and he did not have permission to use the vehicle, and the owner does not want any restitution, even though I think maybe the vehicle was let's see here. He was not real interested in getting restitution because they said the truck was torn up, but he's not going to get restitution from him, so he waived that right. So our recommendation would be, actually, I was going to say 60 days in jail, but I think a suspended sentence in excess of 60 days, and maybe even 6 months. We'd want him to do, he's, I believe, done 7 days, and we'd want him to do another 8 days to make 15, suspend the rest of it, and complete treatment. And the rest of the penalties that go with the OVI, suspended sentence and, or excuse me, suspended license and community service and fine, etc.
Mr. Cronin, do you understand what Mr. Hield is offering you? Do you have any questions do you want to ask about it?
So 8 more days and then to a treatment?
You got 8 more days.
That'd be our recommendation.
On the OVI, you'd be entering a plea to a first offense OVI. You would serve 15 days. The court would assess a fine and court costs, and you would be on probation, and you'd also lose your license for a period of time. And you would be permitted to go to treatment.
And he'd have a suspended jail sentence if he need to be successful, or we'd want him to go back to jail.
Right, they're asking for the 8 days to be held over your head to ensure that you complete your treatment.
Well, more than that, we think it ought to be a suspended sentence of 6 months, but have him do 8 more days and have the rest of it be suspended.
I misunderstood a little bit there then. Do you understand what his offer is?
I thought it was that a suspended sentence and going to rehab Monday, but the 8 days is fine too, it doesn't matter either way.
You would serve 8 more days and you would have the balance of 6 months hanging over your head, as I understand Mr.
That would be our
Hield's
request.
offer. Is that something you want to enter into?
Yeah. Yes, sir.
Do you have a medical card, Mr. Cronin?
Yes, sir.
Which state?
Ohio.
Do you have a bid?
I do.
Do you have any objection to going to a faith-based inpatient treatment program?
No, sir.
Okay, so I'm going to order you to Bethesda for inpatient treatment. All right, anything else you want to tell me, Mr. Cronin, before I finalize your sentencing?
No, sir.
Okay, I'm going to give you the minimum fine because you don't have any money. So $375 is the minimum. I'll give you that as a fine. Order you to pay the court costs. Sentence you to 180 days in jail. And I'm going, and a 6-month license suspension. 180 days in jail. I'll suspend 165 and give him credit for 7 days served. So he's got 8 more days to do. Inpatient with Bethesda with an ankle monitor. Initially, I'm going to have you with an ankle monitor because you took off for a long time there previously, so I'm afraid you'll take off again. And I have to tell you, if you cut the ankle monitor off in treatment, you're going to go to prison for 3 years if you cut the ankle monitor off. On my control.
Did you understand what he just told you?
Yes, sir.
You got that ankle bracelet up and it's a ticket to prison. You're going to prison. No ifs, ands, or buts about it.
Yes, sir.
And you will have to pay for the cost of the monitor. So
I'll set a review hearing. Probably should be a good idea to set it around the time he's supposed to get released to make sure that happens. So that would be the 18th of September. should already be at Bethesda then. So we'll call it a review on September 18th.
Where is that located?
Here in Lawrence County.
Okay.
And then on the driving violation restrictions, $30 fine, no headlight, $5 fine, registration violation, $10 fine, seatbelts mandatory $30 fine, driving without consent. That one I'll impose a $150 fine and 180 days in jail. 165 suspended credit for 7. Okay, so you're going to be going to a good facility, take advantage of it, get clean, stay clean, make this a change in your life. Make it part of what you want to do. Okay, and I'll see you in 10 days. Get a report as to how you're doing. Hopefully good.
Yes, sir.
Okay, see you in 10 days.
Thank you.
Thank you, Your Honor.
Okay, we're not ready for Christy Jordan. Luke's still working on that, so you're done. Thank you. Court will be in recess until, oh, okay, thank you.
State of Ohio versus Douglas Jeffries, case number CRD 23438.
Okay, this is a review that got passed over this morning.
Your Honor, I apologize, that may have been my fault, I'm not.
Okay,
May I approach your honor?
yes.
He is compliant with treatment at OVP.
Oh, this is the motorcycle guy.
Hey, how you doing?
You look a lot better.
Thank you, sir. I appreciate the opportunity, honestly.
You really did. You look, almost really didn't recognize you.
Yeah, it's like I was telling a couple of guys back at the center, like, I mean, I know I couldn't have done what I'm doing right now on my own, and I just want to thank you.
Okay, well, thank you for doing your part. And you have to adopt this as your project.
Absolutely,
You know,
sir.
It has to be, I'm okay with you doing it because I forced you to, but at some
Absolutely.
point, it's got to be done, you got to do it for you and your family.
Yes, sir, yes, sir. I mean, you know, like I said previously, I'm no stranger to recovery, you know what I mean? I just had bumps in the road and, you know what I mean? I just, like I said, I just wanted to thank you because honestly, without you, I probably wouldn't have been able to save my life.
Okay, well, keep after it. You got a good start, but we got to keep working at it, all right?
Yes, sir.
So he's at OVP.
Yes, and
What's going to happen next?
whenever he completes, he is wanting to continue to Bethesda, and Taylor has already said as long as he completes OVP, they will accept him there.
I agree with that. What are we going to do with your motorcycle? It's sitting out here in the...
No, actually, my uncle,
Oh, okay.
they came and got it, and with your permission, that is there any way that I could maybe, not right now, just have him bring it to OVP and drop it off, so when I go to Bethesda, I can have
I don't
transport?
think that's a good idea.
I'm not going nowhere.
You can get it later.
We'll work it out. It don't hurt to ask, I mean,
Down the road.
it don't hurt to ask.
No. I don't think that's a good idea. So no, maybe later, but not now. So when's he gonna finish up
The 22nd is my actual graduation, and the 24th is the 30 days. And I'm working with Mike to possibly leave the 22nd because I'll get my grandchildren the first time in a year.
Okay. So your family knows where you are?
Yes, sir.
And are they supportive?
Yes, sir.
Okay. Probably happy then.
Yeah. Actually, my youngest daughter was the first phone call I made when I left here. And they're no stranger to it, Your Honor. You know, and they've supported me, good, bad, and ugly, but you know what I mean, like, they're super supportive. I mean, they call me on more of my crap than I do, so.
Okay. Well, let's get to the point where, so we need to make them true believers then. They're
Absolutely.
still a little skeptical at this point,
Yeah, I
right?
understand, yeah.
Okay. The longer it goes, the more they're gonna believe in you.
Yes, sir.
So you're doing the right thing, and I applaud that. So let's come back about the time you're gonna finish up. The 20th, you said?
The 22nd.
Second. That just happens to be the court date, so let's have you here then, and we'll decide, just firm up what our plans are gonna be going forward. So,
Be 9 o'clock?
10.
10.
Well, you're right, 9 o'clock.
You guys are great.
You know better than I do, so 9 o'clock for review.
Thank you, Your Honor.
Yeah. We'll see you then.
State of Ohio recalls Devon State Police case number CRV 23494 A and B, CRV 23494.
Okay, we've got an entry which I will approve.
I hope that that does what we intended to do.
If not, we'll try a different way. I'm doing an entry for him to go to the Outpost Developmental Center there. So if this doesn't work, you all need to let Mr. Hill know, and we'll try something different. We'll keep trying until we get something that does work. So I'm approving the entry he submitted. And then we've already got him down for September 22nd as a hearing, just to make sure things are going the way they should. Okay, thank you all for being here today.
Thank you. Thank you.
Yeah, if you need a copy, you can get it from the clerk's office.
If you need it translated, I can read it for you.
Oh, thank you.
The only thing we have left, Your Honor, is Christine Jordan at the Lawrence County Jail.
So I'm waiting to hear back from John Kincaid from Ironton about what can be done about their bond. The place she was talking about is called Brighton Recovery Center. It's in Florence, Kentucky. I got a phone number from them, called them, spoke to, I don't know, clinical director. I talked to somebody there who confirmed that they will take Medicare and they do have beds open. So, and her father's unavailable, but her sister is available to come get her today and take her directly there. So I think that's probably our best option.
I'll enter an order to that effect, then you just have to get Ironton Municipal's modified. Does that work?
That seems fine with me.
And put it on, we could put it back on the docket for Monday in case it doesn't happen.
I won't be here Monday.
Okay.
So I don't mind
At
that.
least that would check, have us check whether she's sitting in jail. Then I'll call Mr. Meadows and say, we need your help. How's that?
I won't be here Monday, so as long as she gets that out. Now, John's supposed to call me back and say, well, Judge Waldo talked to the board, so if he can track Judge Waldo down and get Judge Waldo to agree to make the change, then that should be a non-issue.
Okay, I'll enter an order that she gets a $2,000 OR bond with an order to release to her sister. Do you have a name?
I do, but Kayla. It's Kayla Jordan.
To be transported immediately to
Brighton, Brighton Recovery Center.
Florence, Kentucky.
Yes.
Florence or Lawrence?
Florence.
They probably haven't actually assessed her.
They have they have not, and I recognize that that's an issue, but this is what I'm able to put together.
It wasn't really even just the methadone for us. She's had 200 seizures in her lifetime. She has schizophrenia and multiple personality disorders that she's not been taking medications for. Just a lot of stuff that could blow up if you place her in a facility.
And the father said, or maybe the sister, I can't remember which one said what at this point. One of them said that it's their understanding that that place can deal with.
Well, in any event, the sheriff's not going to want her in jail.
Correct. At some point, they're going to just turn her loose.
Yeah.
So,
And I think once we confirm that she's there, the other case has been bound over to the grand jury, so I don't know whether we would leave this one here until it, we'll just have to make that decision, I guess.
My plan is to put it on the docket for Monday, and then you can decide then if you want. Hopefully you have some confirmation that she did, and then you can decide if you want to disney it for the grand jury, or keep it here, or what you want to do. And if she doesn't go, you can just issue a warrant for it.
Okay.
All right, do we need to get her on to tell her this?
I mean, we need to at least get her on and tell her when our next court date is.
Okay, let's have Christy Jordan at the jail. We need her. There she is.
Oh, they just had her waiting right there for us. Okay.
All right, Ms. Jordan, what I'm going to do, Mr. Steyer was able to talk to your family. Apparently, your dad's not available, but your sister is.
Yeah, my stepmom works as a doctor until 7, so.
So that's Kayla Jordan.
Yes.
Yeah, she also works at the hospital.
I'm ordering you released to her, and you're to be transported immediately to Brighton Recovery in Florence, Kentucky to start your treatment. You're not to go anyplace else, go directly there. And I'm setting, if something happens that you don't get in there, you gotta be back here in Chesapeake for a hearing Monday at 10 o'clock. And of course, if you're still.
Chesapeake.
Yeah, that's.
No, that's the court, that's the court we're in, is Chesapeake Municipal Court. It's across the street from the flea market in Chesapeake.
Well, she's
I
not
don't
from
even
here.
know, this is the
Okay.
first time I've been to Ohio.
Well,
From here.
Google
it.
Write it down and.
Lawrence County Municipal Court, it's close to Huntington. Right across the river from Huntington.
Write it down.
Okay.
But hopefully, you're gonna be in treatment by then. If you are, then you don't have to appear.
And I will talk to your sister. I assume you have no problem by talking to her, right?
No.
Okay. And then she can confirm that you're there and we can take steps. Now, when you get there, you need to fill out paperwork to allow them to report your progress to the court, which again, I would assume there's something at the jail that has the court's information on it. Contact.
Yeah, I'll get it.
Well, when you fax the OR bond over, can you fax a copy of your card?
Yes.
Okay.
Thank you.
That should take care of that.
Okay, hopefully you'll get released today to your sister. Hopefully she comes picks you up and you can go to treatment.
She'll be on her way. Thank you, Your Honor.
Thank you.
You're welcome.
Thank
So,
you, Attorney.
you're welcome.
Have a good day.
You too. Can I raise an unrelated issue real quick? That individual that we had earlier that was a second offense OVI, the vehicle is impounded at Nicely. She lives in Kentucky. That she has asked whether the car could be stored at a storage unit in Ironton. Basically, I guess we're talking about just renting one of those little storage units, which would still be cheaper than paying 90 days of.
I'm okay with that.
Okay. Then I will,
Draft an entry.
Draft an
with
entry.
the address.
I'll have to get that
Have to
information.
be towed.
Yeah, I told her she'll have to pay for towing, she'll have to pay for how long it's been there. I'm not gonna be here Monday, so if I don't get that over to here today, I will probably just figure out a way to get it here next week.
I'm here.
All right, thank you.
Okay, finally. I didn't think today was gonna be that.
Are we done?
Court's adjourned.
Have a good weekend.
You too.
I'll get the bag, Ken.
Thanks.
Back.